Dārgie viesi,
Dear guests, technical information.
technical information. Tātad latviešu valodā
In Latvian, we will have interpreting, so channel number 1, and in English, channel number 2.
the interpretation, the Latvian language is the channel number 1, and the English channel is number 2. Attiecībā uz iekārtu
With regard to use of headsets, so you have to plug in, and then
you switch on or plug in the headset and then only press the button. Only then they start to work. So this is some technical information. And we will start in a minute. Sveicināti Latvijas Universitātes zinātņu mājā. Esiet sveicināti.
Dear guests, we are welcoming you in the Autonomy and Mental Health Care Legal Analysis Symposium for Legal Practitioners. We are happy to see you here in this event. We are really happy to see you all here, that you have devoted your time, that you are interested in this topic, and you represent here very many sectors, spheres, doctors, you are practitioners, policy makers, experts. Thank you very much for coming, for joining, because without you, without common efforts, this aim is not achievable. I would like to thank every participant of the symposium, but we also can have participants remotely, and this event is being streamed on the homepage of University of Latvia, also Ombudsman homepage and website, and it will be also available for tomorrow's conference. That is technical information. So now I would like to give the floor to Mr. Juris Jansons, Ombudsman of Latvia, for opening this symposium.
Jā, paldies, Ruta.
Thank you, Ruta. Thank you. Dear participants, dear audience, excellencies, ladies and gentlemen, colleagues, peers and friends. I'm really honored to open a symposium, Autonomy and Mental Health Care, a Legal Analysis. I'm really honored, and I would like to say that maybe it's I have to say that we haven't been in such a number and with so many participants, with such participants and people ready to discuss. So we have for the first time such event. I think it is the first time. As we all know, this topic is very, very, very sensitive. It is very stigmatized in society, and I'm really happy that we could develop this topic, so that we will have discussion, because it's very, very important. Professor, I think you would agree. I'm really happy to welcome you all here in Riga on the week of national holiday. And also those people I would like to welcome who are joining us virtually, remotely, because I think that it's very, very important that we can listen to different opinions, we can participate in discussions and develop this topic. This symposium, together with tomorrow's conference on autonomy and mental health care of people, is very, very important, not only for me as an ombudsman, but also for the whole institution. So it's not, sometimes I hear that you are alone, but this is institution. Ombudsman is institution. It's important also for Latvia, and I'm sure that for all other countries of European Council. So I think that in all countries this topic is very, very topical, and it's important that we all speak about this, that we find solutions, and both international and national legislative acts stipulate different rights for people, and these rights are for every person, and they prohibit discriminating people on the basis of different aspects. But historically, we know that people with mental disabilities have been regarded as people with for whom which we can deprive of some rights. If you remember, some time ago it was full restriction of capacity and capability. So right now it's not true anymore, but you cannot deprive of every capability. But so we have to do a lot regarding this. We have to decide, we have to talk to people, to society, and also jurisdiction has to develop regarding this very sensitive topic and these aspects to limit or restrict rights of people with mental disabilities. For a long time, it has been accepted as a fact, and now we can say that right now it's not right anymore like this. So we would like to rearrange all these mental health care aspects so that this meets respect and needs of all people. And as the court has stipulated in many of these its statements, so respect is one of our constitutional values. So this has been stipulated in the preamble of the Constitution. And the purpose, not dreams, and this means that we are ready to do something and ready to make step by step. Yes, sometimes these steps have been very small, very short, they have been maybe too slow, but regardless of the fact, we have been forwarding, we have been developing, and we are making a step towards society where every person is respected and where the quality of every person is valued. And we are not allowed to stop in this development pace, because respect of rights is not just event to celebrate and to forget. So this is a continuous process, this is a progress, so we are involved in all this, and we have to continue. Therefore, I wish and I hope that our today's symposium, our speakers, will provide us with seed for discussion. What is the autonomy of a person? Why is it so important? And what role here plays legal framework? So, providing us insight and providing us opportunity to develop even further and to make our judicial space better. Ladies and gentlemen, friend, I thank you for joining, for interest in this topic, in ensuring autonomy for people with mental disabilities, and I wish you to this fruitful work today. Thank you.
Paldies, tiesības.
Thank you to Ombudsman of Latvia for opening the symposium. As it follows from the title of the symposium is really devoted to legal analysis today, and therefore I would like to invite Parliamentary Secretary of the Ministry of Justice, Ms. Lauma Paigļi-Kalna, for some introductory speech. Dear guests, I'm sorry, ladies and gentlemen, peers, and like-minded people, I'm really delighted to welcome you at the symposium today for ever topical topic of autonomy and mental health care, a legal analysis. From legal perspective, we are living in the time when the world starts to recognize the principle of autonomy and dignity both as a source of inspiration and a legal principle. It means that a country should respect natural equality of all people at first, and facilitate freedom of all the people at the same time. And this human dignity-based implementation of freedom, enjoyment of freedom, is self-determination and autonomy of a person to be expressed, constituting private and public life of a person we will be discussing today. Human dignity makes us open our eyes wide open to notice our people around us and experiences they have had, which manifest hierarchy of socially constructed structures with normal, abnormal, desirable and non-desirable parts, which are considered to be physically healthy, and bodies which are not considered to be such, which is really important for our today. As a topic and discussion is differently functioning bodies in the framework of values prohibits maintenance of such a hierarchy, and therefore it is really a logic that the public voices various challenges of those people more and more. Those bodies were considered as non-desirable or not inclusive and have been at the bottom of such a hierarchy or pyramid. These are people with functional disabilities and mental disorders. Situations of their relatives and kinship is both very hard emotionally, physically, and I can't really witness that because I have my brother has such a very difficult disorders. For local and regional governments, for the state and for the society, there is a really urgent need to find solutions to improve situation of such people. By thinking over potential solutions for functional disabled to see as a full-fledged members of society, which, according to one's capabilities and skills, can join the full-fledged life of the society. We must really avoid from a stigma that these people are only an object of care, but that they are really full-fledged human beings. For a person to be able to implement and realize oneself, environment must be appropriate. And for family must be appropriate and fit with social provision, emotional support, physical support, and all social and healthcare services being at the disposal of a person and his or her family when it is needed. Symposium today and conference tomorrow are significant for facilitating and raising awareness of the society on experiences of people with mental disorders and with some disordered mental health. Although Latvia faces a set of solutions being developed for vulnerable people's protection in a legal system, which has taken place in last 10 years. The protection of 2000, the Hague Convention, and Latvia has turned from a country where a person is announced to be incapable into a country where only tangible and property rights may be deprived or limited to some extent, and of the best protection of a person. 10 years have passed since the limited capability, guardianship or trustee principle and institutes exist in the country. Currently, personal rights may not be deprived and limited, therefore, on treatment, on medical treatment or inclusion or hospitalization to a special institution is at the freedom of a person to decide and decision making, as well as service to be provided. Services may be provided both to people for property rights or property issues being discussed and solved, but also as regards medical treatment. As Ombudsman has rightly mentioned, we have a lot to do yet, but we have to find the ways to support people and to really eliminate those bureaucratic processes and procedures which exist and which really hinder the progress. Good lawyers see how the legal system is, but excellent lawyers see what the legal system should be. And our vision of Latvia and of the European Union exists already in the minds of excellent lawyers when the draft law and draft directive are in the pipeline. I believe that clear vision on a better way towards future legal system where all people will be equal, we will have in the result of Symposium today. And I'm delighted that with such a competent specialists and experts, Latvia has its way towards progress. Thank you very much, and I would like to wish you a very fruitful discussion today at the Symposium. Thank you to Parliamentary Secretary of the Ministry of Justice, Ms. Lauma Paigļkalne. And now I would like to pass the floor to Professor Sanita Osipova, Doctor Juridica, Professor of the Faculty of Law of the University of Latvia, Senator of the Supreme Court of Latvia, for her keynote speech, Human Dignity, Equality, Inclusive Society. Ladies and gentlemen, excellences, I'm happy and delighted to welcome you. On behalf of the University of Latvia, University of Latvia is proud that its scientists and students have implemented interdisciplinary research within the framework of the research project, Human Rights-Based Approach to the Treatment of Patients with Mental Disorders and Limited Decision-Making Capacity, Legal, Ethical and Clinical Perspective. The aim of the research is that Latvia would become a better place for every person to live and to create a more inclusive society in the future, for us to be happy that everyone feels at home in our country. The Symposium, opened today at the University of Latvia, shows the importance of international cooperation among universities. As Estonian, Lithuanian and British colleagues joined Latvian researchers in the research, and the Symposium is convened in cooperation with responsible ministries, courts, lawyers, local and regional governments and other cooperation partners. The University of Latvia thanks our partners in organizing the Symposium, namely the Office of the Ombudsman of Latvia, the Ministry of Foreign Affairs of Latvia, and the Latvian representation in the Council of Europe, as well as all researchers who are ready to share their knowledge within the framework of this Symposium. Why one needs to talk about the dignity and equality of every person? Because historically, the full rights of a person were determined by gender, age, origin, occupation, and other personal characteristics in various cultures. Knight could not be abnormal person. He had no rights in the system. Personal freedom was limited and equality was recognized only among equals, while full rights were enjoyed only by a small part of society. And if we are reading Human Dignity in Encyclopedia, we will find a lot of different meanings. In philosophy, there are concepts on human dignity, and they have quite a vague meaning. Lawyers are clear that human dignity is stipulated both in laws and regulations, and meaning and content is first of all explained in the constitution of the country and international law. by courts considering cases on violation of human dignity. However, everything has changed in Western culture since the late 18th century. Among other things, these changes were facilitated by the School of Natural Law and the philosophy of the Enlightenment, within which human freedom was recognized as a natural and inalienable right of every human being. Modern Western democracies are legal states in which the fundamental rights of a person have been expanded dynamically, with equality and freedom gaining special importance since the end of the World War II. Where the freedom and dignity were the top principles being enshrined. In the documents establishing the Republic of Latvia, freedom has already been emphasized as a value to be protected, and the demand for equality of persons has been included. However, the understanding of what exactly personal freedom and equality includes has changed significantly in the 20th century. The limits of personal freedom established by law have been rapidly expanded. The expansion of the boundaries of personal freedom was influenced both by significant changes in public consciousness and by the new practical benefits provided by science, namely the provision of goods and services that were never possible before. This new freedom affected all areas of a person's life, both by providing new opportunities to choose in occupation, as new professions were created, and freedom in private life, because the freedom to divorce increased due to decreasing influence of the church, as well as more and more people formed their cohabitation without getting married. People opened up to more and more opportunities to travel, which was facilitated by both the offer of new means of transportation and an organized and simplified visa system, etc. Thus, the limits of personal freedom are constantly and dynamically growing in the synergy of the opportunities offered by science and technology with the strengthening of liberal legal opinion in legal sources. Freedom of expression also takes on other forms, as the ways and means of information distribution change, which in its turn causes significant changes in society itself. But it is not available to everyone due to one's physical or other reasons. They cannot be included in the society of those freely flying around people. Freedom of expression also takes on other forms. What is equality, what is equal, and which are criteria forbidden to discriminate against a person has changed during the 20th century. In 1948, Article 1 of the UN Universal Declaration of Human Rights defines a requirement for human dignity and freedom of all people, but Article 2 includes features on which a person should not be discriminated against. Everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. These were the criteria for the prohibition of discrimination, which was considered exhaustive in order to ensure the equality of all people in the mid-20th century. The European Convention on Human Rights, which was adopted a little later, stipulated the prohibition of discrimination. Without discrimination on any ground such as sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth, or other status. Namely, national minority and state of birth were determined as additional criteria, and a status of health was not included, although they could also be read in the text of the UN Declaration, where they highlighted expresses verbis. In its turn, the Charter of Fundamental Rights of the European Union, developed at the turn of 20th and 21st century, in addition to all of the above, includes a ban on discriminating against a person on the basis of genetic peculiarities, disability, age, or sexual orientation. 50 years have passed since UN declaration was adopted, but everyone was not actually everyone, because there were groups which were not considered equal to other groups of the society. In Latvia, The Council of Europe Convention on Prevention and Combating Violence Against Women and Domestic Violence, or Istanbul Convention, which caused a lot of acute debate in Latvia, includes one additional criterion in addition to the prohibition of discrimination, and namely gender. I will not analyze the new criteria ever included in international human rights documents more deeply. It is essential that ever new criteria have been recognized and included in legal acts over time, which hinders the achievement of true equality and which doesn't allow every person enjoy human dignity and equality. In each of the above-mentioned documents, the legislator has tried to include all stereotypes and prejudices prevailing in society exhaustively. If we talk about the right to self-determination, the right to decide about one's life, then it is precisely these rights have been changed most dynamically within the framework of the mentioned concepts. Until the 20th century, a small part of society enjoyed full rights, such as adult, mentally healthy white men. According to the will of a father of a family, the freedom of both his wife and his minor children could be restricted, including placing them in mental sanatoriums or really apply some force in good faith if they behaved abnormally and placing them in those mental sanatorium. Women's emancipation changed the situation, which lasted until the 80s of the 20th century in several European countries. On full-fledged decision-making by children, we have started talking even later. According to the principle of patient autonomy, every capable patient has the right to active participation in decision-making about the methods and means used in his or her treatment, and he or she is guaranteed the right both to receive medical care and also to refuse it, even if the refusal could result in damage to his or her health and life. In Latvia, I cannot refuse from resuscitation, because at the moment when I should be resuscitated, I am unconscious, and the country decides on my behalf that I could be donor, but on resuscitation there is no decision made, and this is in our to-do list yet. However, the idea that mentally ill persons also have human dignity, which includes the right to self-determination, came even later. Public opinion divided people into normal and non-normal for thousands of years. Each society develops a normative structure that fixes a standard of normal behavior. And if you do not behave normally, there is social correction. This is how society expresses its collective attitude about everything that happens inside or outside of the group. Social phenomena and relationships are evaluated according to the common scale of values of that society as positive or negative, and the normality of behavior or compliance with existing norms and the abnormality of behavior or non-compliance with existing norms and values are determined based on this evaluation. The society's assessment on individual persons or social groups' conformism or integration into society or inappropriate behavior results from that, which is a deviation from the social norm and what we do about them. So it is most easy for us normal ones to isolate abnormal ones. If someone is abnormal, then he or she cannot enjoy the same rights as a normal person. We only excuse ourselves that we are protecting normal ones. However, the development of human rights has changed everything. We consider ourselves to be normal and we protect ourselves, in fact. Development of human rights has changed many things. When understanding that a part of society is restricted following the idea of majority about normality, which varies in different cultures by the way, they began to promote that society revised its attitude in order to show people with mental problems a respectful place in an inclusive society with the help of law, as it was many years ago that under Soviet rule, dissidents were placed in mental sanatoriums. We have different understanding about normality in various cultures, and by the help of law, the state has promoted revision of attitude of public opinion in order to show people with mental problems a respectful place in an inclusive society. Otherwise, this society may not be considered full-fledged. So, we have gone from treating mental illnesses with sadistic means such as cold baths, lobotomy, electric shock, to demands for human treatment methods just in 1 century, and self-determination of patients. In their turn, legal concepts are being changed about the extent to which persons with mental illnesses can decide for themselves about their lives. The turning point in the Latvian legal system was judgment number 2010-3801 of the Constitutional Court of Latvia in 2010, in which a person with a diagnosis of mental illness contested Section 358 of the Civil Law, which had stated, "The mentally ill who lack all or most of their mental abilities are recognized as incapable of action and legally incapable of representing themselves and managing their property and dealing with it, for which reason a guardianship is appointed over them." Namely, all of the mentally ill were completely deprived of legal capacity. The applicant controlled her illness with the help of medication, and she was able to integrate fully into society, including she wanted to start a family, but it was a woman who had a bridegroom who knew about her illness, but he wished to marry her, but the law forbade her to marry. The Constitutional Court of Latvia concluded that the restriction was disproportionate because there were alternative means that limited the rights of the person, less as there are various methods that the state can use to limit the capacity to act in accordance with human rights requirements. An example can be partial restriction of the capacity to act, as rightly mentioned by the previous speaker. Support in decision-making, personal assistance, compliance with previously expressed instructions, etc. Also, the models selected in different countries are different and vary. Partial limitation of capabilities planned in many European countries, such as the Czech Republic, Croatia, Estonia, Poland, Germany, and elsewhere. Thus, for example, the Estonian Civil Code stipulates that in cases where a trustee is appointed for a person, his or her capacity to act is considered limited in the matters for which the trustee is appointed, and this is the procedure Latvia has also taken over. The court must decide in each specific case which activities the person is able to understand and manage, and for which he or she should therefore be appointed a trustee. Whereas in the Netherlands and Luxembourg it is possible to appoint a trustee for a person separately from the guardianship institute. In its turn, in Norway, a person with a mental health disorder can enter into contracts, but a trustee can request their annulment in certain cases. From that moment on, Latvia joined the family of countries that created an inclusive society where mentally ill people also enjoyed equality and human dignity. And as you can see, there is a pioneer breaking the ice. I am happy that that woman started a family, but this forging a family took many institutes to pass for her so that it could be implemented in life. Thank you.
Paldies, profesore.
Thanks, Professor. Thank you very much. Thanks to Mr. Jansons, thanks to Ms. Paigakalna for opening Symposium. So Symposium has been opened. And now I would like to invite a moderator of the first panel, Professor Māris Taube, who will be moderating the first panel discussion, Key Principles in Securing Autonomy in Healthcare. Professor Māris Taube, Dr. Medica, President of the Latvian Psychiatrists Association, Professor at the Department of Psychiatry and Narcology at the Faculty of Medicine of Riga Stradiņš University, and Head of the Riga Psychiatry and Narcology Center. I would like to invite also Associate Professor Signe Bežīnska from Faculty of Medicine and Institute of Clinical and Preventive Medicine from University of Latvia. And also I would like to invite Mr. Alex Rack-Keane from UK, Professor at the Dixon Poon School of Law, King's College of London, and also Stephanie Woolley, European Network of Ex-Users and Survivors of Psychiatry.
aicinu ieņemt labākās vietas un lai ir ražīga diskusija.
So please take your seats and let the discussion begin. Hello, hello.
English, yeah, because our lectures are from not Latvian-speaking countries, and it's a great pleasure to be here as a psychiatrist, because we are also somehow in front line, and all those questions is quite important also for us, and we very try to enjoy and try to get a lot of information, a lot of help for our work for future. But let's start with some presentations from each of our panelists, and then we will do ask some questions. We will provide some discussions. Yeah, and first lecture is Professor Signe Mežinska from Latvian University Medical Faculty. She's well known in Latvia and also in other countries and other different projects, doing a lot of in area of health, legal aspects and advocacy of patients. Please, the floor is yours.
Paldies. Labdien.
Thank you very much. Hello, ladies and gentlemen, participants of the symposium. I'm really happy to be here in this event, and as previous speakers already mentioned, this is really the first time event. Never ever we have had such an event where we devote so much time to a topic which we have not discussed in full. So we have actually tried to avoid deep discussions. And my task today is to speak about autonomy, about bioethical and philosophical aspects of autonomy. I'm not a legal expert, I'm an expert of bioethics, and I would like to show the aspect of autonomy, development of this aspect. I will try to do this within 15 minutes. But to show how it has changed, how understanding of autonomy has changed in bioethics, and how this influences the law as such. To start with, I would like to cite George Stone mantra, or Bichmost Childress book, Principles of Biomedical Ethics, which was first published in 1979, but this is the 5th edition from 2001, where the authors say that respect for autonomous choices of persons runs as deep in common morality as any other principle, but little agreement exists about its nature, scope, or strengths. This is the first sentence in the chapter on autonomy and respecting autonomy of a person, and I think that authors emphasize this very groundedly, because there is real discussion, continuous discussion about autonomy and its definition. When preparing for this speech and presentation, I also looked into the a translation of ANO United Nations Convention, and I was quite surprised. What is named as respect in English is translated as respecting independence, or
Šo iedzienu diskusijai par to.
so we can actually discuss whether this Latvian version is perfect, or I think that I will have some objection towards this type of wording, but we do not have time to discuss this. Anyway, what also previous speakers already started and mentioned, so there are issues regarding how understanding of autonomy and implementing autonomy changes in modern world. And if in short I have to show this, then we are in transition from taking decisions instead of a person or in interests of persons, because the best interest, of course, of a person was valuable or on the first place, in theory at least. and we are in transition to independent taking decisions or supported taking of decisions. And actually here we face different questions. But to understand what this transition means, we have to start with understanding what really autonomy of a person is. And if we look in a rather respectful source by respectful authors like Internet Encyclopedia of Philosophy, there we see that autonomy is an individual's capacity for self-determination or self-governance. So, self-governance or self-determination. But then there is a question, what is autonomous action or activity? And what we perceive as such activity, and in bioethics, we perceive this as activity which a person performs consciously and without controlling influence, which is determining activity. Of course, we can discuss what it really means, how we can be sure that, or whether we should be sure about this, but I would like to emphasize also, Professor Osipo mentioned that autonomy is also a freedom to perform choices which maybe do not match with other person's ideas about the best choice. And autonomy is also freedom to perform choices and to make mistakes. This also belongs to free autonomous rights of a person to make mistakes. If you think about autonomy from a point of view of bioethics and we come close to practice, I would say that information is very important. When any choice is not autonomous, autonomous choice, and for making autonomous choice, you need available information. And here, if we think about what we are trying to introduce right now about support in making decision, this means that these are our strivings to interpret or translate complicated information, for instance, medical information, in a way understandable for the person and to make sure that the person really has understood that information. Of course, also in bioethics, here we have quite a lot of questions. Also in UNESCO declaration, where we see adequate information. We could ask what is adequate information. We can ask what do you mean by making sure that the person has understood that information. But we should accept this, so it is important and it is significant, and we see that public in general strives for that information also on the internet and other electronic media is available, accessible for people with special needs. Why information is so important? Information provides opportunity to consider different possibilities to act, different risks, also benefits within the context of personal values. And if information is available, sufficiently available, a person can provide informed consent. But I would like to put a step back and look into the history of autonomy and see where we are today. So I cannot start with antique world, but and also through political and police autonomy comes into our lives, and it starts also with antique world, also Kant's philosophy is very interesting and so important for this. And also, as Professor Osipo said, that Enlightenment is the era when autonomy became a very, very important topic in philosophy. But I think that it is important to mention British liberalism. And it's clear that the idea about the fact that individual is in the center and individuals should be provided bigger freedom, that we should address against every ideology which are for not freedom, and individual freedom is also a basic norm for society, and this comes from 19th century. And John Stuart Mill is one of the fathers of this idea. Also, we also have to remember that liberalism came together or hand in hand with detriment, which restricted the freedom of individuals. In liberalism, it is not limitless. So person is free as long as his activities is not hindering others. So there are some restrictions for freedom. And next, one more, which also which I would like to mention, which we should not forget, and we should mention in this context, of course, is Riga-born British philosopher Jesaja Berlin, who in his 4 essays on freedom says, and I think this is really essence of autonomy, I wish that my life and my decisions would depend only from myself, not from any other external forces. I would like to be my instrument of my will, not that of other people. I would like to be subject, not object. And of course, this is very concentrated manifest, and this is really clear that of absolute autonomy, even in philosophy, is not possible. I doubt that it is possible, that person is really autonomous in taking decisions and independently of anything. And also I would touch upon autonomy a little bit later, especially about feminist autonomy, where there is this emphasis on relationship with other people. But I think that Jesaja Berlin actually really well shows this ideal, our internal wish to be respected, to be heard and understood. But the notion of autonomy, interpretation of it in a classical way, which was also taken by Joel Feinberg. So for this approach, we have actually a drawback, which we saw also in people saw also in practical life, and this was related to binary approach, which was explicitly explained by Joel Feinberg, and he's a lawyer. He speaks about autonomy and introducing autonomy or implementing autonomy and telling that there could be that there are different situations. It is possible that a person has capacity of self-determination and rights to self-determination, but the person is not implementing this in practice. But also he says that hypothetically there could be a situation in which person has both self-determination capacity, possibility to implement this in practice, but rights to self-determination is not recognized. And this is what I said before, that in previous also we here in Latvia have admitted and such situations when people with capacity here, we do not recognize their rights to self-determination. But this binary approach, and as you see, this is 1988 when Feinberg writes this. This is what I have said in the 3rd bullet point, that if a person fully lacks the capacity of self-determination, it cannot implement self-determination. Thus, a person doesn't have a right to self-determination, and this is this depriving of the self-determination and capabilities and legal capacity. But this is contradicting the previously mentioned aspects that when we say the person is either autonomous or not autonomous, because in the theory of autonomy, the choice is perceived as more or less autonomous, although this borderline between persons who are capable of passing decisions or persons who are represented by representatives is dichotomy, which requires to split people in two groups. And this actually is perceived as a problem. And this is why we are changing the approach to the autonomy also in our practice, since always we have that question how to divide those people into those two groups. And in bioethics, the case studies shows that there have been a lot of cases, many such examples, when people have been put in the group where they are not autonomous and they do not have rights to take decisions without clear argumentation and clear arguments. So decision has been taken against the capabilities of the person. So right now we do not take that binary approach, and instead we say that we do not have to put people in two groups, autonomous or not autonomous, but we have to make an environment in which people or person can exercise his or her autonomy abilities, self-determination abilities, receiving all possible support, including information which is understandable to him, to her or him. So, of course, all these stories are rather complicated, and I could read a lecture or even a course of lectures or 3 months courses about different theories of autonomy. And it's clear that also those different approaches provide and offer different solutions. But here we see 3 different groups of this autonomy in philosophy. So first are content-wise neutral or procedural approaches, so which are neutral regarding to types of agents, values, which provide criteria for the person's activities and can be perceived autonomous. Then there are these substantial approaches where they provide restrictions, and those are followers of Kant, Immanuel Kant, for instance, who likes this approach. And also I would like to shortly mention a feministic approach, which will actually influence also our discussions in future. And in those cases, it is said that they are very, very valuable, but anyway, they ignore this social relationship and networking fact. And these very individualized theories of autonomy, and we do not adopt or make the decisions individually, and most probably you will face also those relational autonomy, so trying to find the correct direction. And approaching a summary of all this, would like to tell where we are. So we were at the crossroads of autonomies, so theories of autonomy and the use of these theories, so binary approach, where we see that where we saw that this led to breaches or a violation of human rights. And now we are on the way of supporting decision-making and not this division in two groups. But at the same time, there are also different issues. How exactly to support in decision-making these people who were some time ago perceived as incapable of making decision. And so we have quite many discussions, and also we have here that says a person's autonomy should be respected, and they are allowed to make their own decisions. And also the authentic issue or notion of authenticity. I do not know how it is in legal aspect, but authenticity is very essential for bioethical aspects because decisions of a person and activities reflect their authentic features and values, and these values form their identity. And as a conclusion, what we should speak about, or what we should take into account, what we should think about when we make steps towards this taking supported decisions, we should accept and we should understand that support of person autonomy means that person should be helped and assisted to decide and act in compliance with their personal values and coherent valuations. So we have to understand those people. We have to allow the person to participate in decision making and to control their decisions, and also the person has rights to take the risk and to make mistakes. But I will conclude with open questions in bioethics, and there are questions, and we also try to find new approaches. But since these open questions which we will have to answer are as follow: how to act if the wishes expressed by the person contradict values of the very person. Such situations could arise. Or can, in these situations regarding, like with material values, we can say that we have the best interest is not to take that decision, and is it allowed to restrict or limit self-determination of the person to promote this authenticity? Not always see this choice of the person promotes or facilitates his or her autonomy and what to do in such situations if the supporter has doubt regarding this. But I think that in general we are in the right direction, and it's clear that such autonomy or understanding of autonomy which leads to the violating human rights doesn't work. We have to look and find correct, better solutions when supporting these people, and we have to make a suitable environment for every person. Thank you very much.
All this.
Thank you.
Speaker is Alexander Rukin. How it's written in the webpage, incredibly well-respected person, and I hope so. Also, it seems to be like that. He's working in King College and also did a lot of work in the policy-making process and advices. And we hope so. Listen your presentation, please.
Thank you very much, Excellencies, ladies and gentlemen. Thank you very much for the invitation to speak. I'm really honoured to be amongst such a distinguished group of people thinking about these issues. I'm going to offer some very modest thoughts from England and Wales. I'm going to do so in a personal capacity. I'm a lawyer. I act on behalf of clients. I'm also a consultant at the moment to the Law Commission of England and Wales, thinking about social care for disabled children, but I'm not talking in anything other than a personal capacity. And that second point, apologies, I should have translated my slides into Latvian, I apologize. That second point is the most important thing I can say. I am not here to say the law in England and Wales or practice in England and Wales is perfect. It would be very rude of me, very arrogant of me to come here and preach. All I'm doing is sharing some thoughts about how we think about decision-making capacity for your benefit. And you can do with them as you will. So if the previous speaker said we could have a course, I could have a course too. I only have 15 minutes. So I just want to give you, these are the principles in our Mental Capacity Act, which applies across the spectrum in terms of decisions about care, about treatment, about money, about sex. We could have a very interesting discussion about sex. We don't have time. Those are the principles. The first, I think, is universal, an assumption of capacity. The second, that a person cannot be found to be unable to make a decision unless all practicable steps have been taken to support. So feeding in from the previous speaker, this idea of support. That third one, if you go back in history, it's apparently that English people are very eccentric. And the idea is that we must try and make sure that individuality is recognized. Those are the principles. They may not be applied, but that's the principle. And our idea of mental capacity is set down there. It's functional. Can the person understand the information? Can they retain the information? Can they use and weigh the information? And having done that, can they communicate their decision? The person in a coma, how do we know? Can they make the decision or not? We don't know. And a person in England and Wales can only be found to lack capacity to make a decision if that inability is caused by a temporary impairment or disturbance of the functioning of the mind or brain. They're unconscious. They've just been knocked over by a car. That's a temporary impairment. Or a permanent one. They have an intellectual disability, say. But there has to be caused. There has to be a causal link. So it's not meant to be status-based. It's not meant to be, you have schizophrenia, you cannot make decisions. So what if you have schizophrenia? It's only relevant if your schizophrenia means at the point you need to make the decision, you cannot use and weigh the information, say, and that is directly caused by your schizophrenia. As I say, that's in principle. You will be able to give me examples where that isn't adhered to in practice. And it's meant to be time-specific and decision-specific. So that's how we try and think about mental capacity. And actually, it was really interesting hearing the previous speaker and this idea, for instance, of authenticity. How do we grapple with authenticity and autonomy? Because I want to give you a very hard, very recent case. And this is the sort of case we need to be able to have a response to. And I am thinking particularly here about the Convention on the Rights of Persons with Disabilities, which I'll talk about a little bit more in a minute. So this is a man. He has a very long-standing mental health condition. It's very graphic. I was going to give a picture of his ulcers. You can see the bone in his leg. His skin is hanging down. He is screaming in pain. but he refuses to allow anyone to touch his leg. How do we respond to a situation like that? And I have to say, unless people have a coherent response to that case, that is a real, hard case, then ethically and legally, we have a real problem. The solution in England and Wales, at least this judge, and again, I'm just offering this as how this judge thought about it. You can come up with a different formulation. This is viewed through the prism of his mental capacity to decide. If he doesn't have those ulcers treated, at a minimum, he's likely to lose his leg. He's actually quite likely to die. This judge finds, and this is a sort of one of the sorts of explanations you might see as to why this man cannot make this decision. You might be interested in reading the actual case, because what then happens is really complicated. Not least, he has a heart condition. If he is restrained or sedated to try and treat his ulcers, he might well have a heart attack. What do we do? England and Wales thought through the prism of best interests. You can think about it how you wish. But unless we have solutions for problems like this, autonomy becomes very problematic very quickly. So I said I just wanted to mention the Convention on the Rights of Persons with Disabilities because that is the driving force behind a huge amount of change, massively important. The CRPD itself does not mention the concept of mental capacity. It talks about legal capacity, the right to be recognized as a person. The CRPD committee, the treaty committee, do not like the idea of mental capacity. They suggest that it's discriminatory. It asserts a degree of objectivity which doesn't exist, and it purports to be able to look inside other people's minds. So they say it should not exist as a basis upon which to proceed. And that comes very strongly, I would suggest, from concerns about specific areas, in particular psychiatric treatment. Situations where people have had psychiatric treatment imposed against their will. My advantage, or it may not be advantage, is that the cases I do, psychiatric treatment, people with intellectual disability, people with dementia, people with acquired brain injury, across all types of life. Does that concern about involuntary psychiatric treatment mean we should abolish a concept which applies equally, at least in England and Wales, after a car crash? If you can only ever provide treatment on the basis of informed consent, how do you proceed? How do you proceed for the person in a coma? Can you treat them? No, because they can't consent. It gets very complicated very quickly. And I would just point out or bring to your attention for people interested in thinking about the CRPD, this is the Australian Law Reform Commission. They thought very deeply about a framework for supported decision-making. It's one of the most detailed processes for trying to think through how do we actually support and enable all individuals, no matter their level of cognitive impairment, to be recognized and exercise their rights. They don't think the concept, the functional concept of mental capacity is per se discriminatory. And interestingly, the CRPD committee, in their concluding observations on Australia in 2019, say Australia should adopt the recommendations of the Australian Law Reform Commission. That, to me, is a very pragmatic, a very effective, very powerful tool to move forward in a debate which sometimes otherwise can be very polarizing and very unhelpful. I said I could give you a course. This would be my reading list for the course, if you are enthusiastic. That is a link to a page on my website with quite a few articles thinking about how we think about capacity and quite a few videos. I have not left my shed in England much since the pandemic started. So I have recorded lots of videos about capacity, about concepts like deprivation of liberty. So some of those might just be useful to you. And that's all I wanted to say. So thank you very much.
Thank you very much. Also, our last, not least speaker is from European Network of Ex-Users and Survivors of Psychiatry, Stephanie Woolley. We will listen a little bit more about autonomy from other points of view.
Thank you so much for this invitation to present a point of view at this legal symposium with such distinguished speakers and scholars on the program. That point of view will be from a person with lived experience of being deprived of legal capacity and the ensuing results, including myself, and not strictly from the point of view of a patient, as worded in the program, in spite of my request for a change of this term. Words are powerful and reflect the major power imbalance in this realm that so many of us have survived, but not without it having a huge impact on our lives. This is an important point I would like to stress in this presentation. So here I stand before you today, but I put this slide of some of our heroes with lived experience championing our cause for equality at the Conference of State Parties to the UNCRPD a few years ago, as an introduction to give me some courage and strength to be here today. Special mention for Jolijn Santagoods on the right, that many of you may have been lucky enough to know, who has since left us and who fought for many years for our rights in this same forum. So a few words about the organization I represent, ENUSP, the European Network of Users, Ex-Users, and Survivors of Psychiatry. It's been a really amazing experience for me to be part of the only European NGO exclusively composed of persons with this lived experience and representing persons with this lived experience in 28 European countries, and members of our impressive network of allies and partners in Europe and beyond, lobbying alongside them for advocacy and for awareness. So, just as a reminder about how important this conflict of laws and conventions between the international and European levels is to us. It has such an important impact on our lives. Regarding the rights of persons with disabilities, the UN CRPD and its authoritative interpretation of human rights standards established by the UN CRPD Committee, democratically elected by UN member states, must prevail. The Vienna Convention on the Law of Treaties is there to ensure this. This means that legal reforms, as has been said earlier, are necessary to hold up these standards, and particularly at the European level. INUSP and Jolijn Santegoods, I mentioned earlier, have denounced the use of Article 5.1e of the European Convention on Human Rights dating from 1950 as grounds for detention of persons with disabilities, along with the entire chain of ensuing standards and provisions that need to be amended, which still allow involuntary detention and treatment, such as Articles 6 and 7 of the Oviedo Convention, the 2017 CPT standards on means of restraint in psychiatric establishments for adults, or naturally the idea dating from 2004, before the UNCRPD, to come up with an additional protocol to the Oviedo Convention. These represent impermissible derogations of the rights of persons with disabilities enshrined in the CRPD, and they cannot continue. Efforts being made by states towards the implementation of the CRPD must be encouraged. We want Europe to be a champion of human rights for our community, and we have constantly encouraged the Council of Europe to align its human rights standards on the right to liberty and freedom from torture. Also, as a reminder, but I won't read this, I'm sure most of you here in the room are very familiar with general comment number 1, already mentioned. It's to read later, perhaps. I'm sure you know this by heart, but it recognizes the deep pain and trauma as a result of forced treatment, how this violates many rights of persons with psychosocial disabilities, and it talks about the respect of legal capacity at all times, including in crisis situations. And these principles were enshrined in the guidelines on Article 14. If you're unfamiliar with these guidelines on Article 14, liberty and security, I really suggest you read them on the CRPD website, the OHCHR website. Or this 2017 report from the Special Rapporteur on the Right of Everyone to the Enjoyment of the Highest Attainable Standard of Physical and Mental Health, Danius Purris, your neighbor, a child psychiatrist himself, who recognized that people suffer more from the discriminatory and inappropriate care than from the natural effects of any mental health condition. And he recognizes that substitute decision-making must be ended and that support must be provided at all times to make a decision, including in emergency and crisis situations. But to focus more on the impact, struggles, and expectations of our community, I would like to cite a peer from France who explains, "It seems to be a futile struggle between small and great, the clay pot versus the iron pot. The medication I'm taking doesn't encourage me to take action, even if, as a victim of psychiatry, there's a wind of anger inside me blowing against this inhuman system. But as a psychiatric patient, I'm still in the hands of psychiatrists, so I'm powerless and far from having full freedom of speech. After 3 years of fighting with several psychiatrists, I managed to get the antipsychotic injections replaced by an oral treatment. I can see that the psychiatrist who agreed to this change and who is assigned to me has very little trust in me. To really know what it's like to be caught up in psychiatry, you have to be a victim of it, to have suffered the mental torture and coercion that has been put in place, and to know the feeling of fear that this discipline engenders. As a user, psychiatry has taught me 3 things: contempt, fear, and a feeling of powerlessness and insecurity. You have to understand that the mere sight of a police car driving by, or the sound of a fire engine or ambulance siren, sends a wave of panic through me and makes my heart beat faster. Such is the trauma of the forced hospitalizations I have undergone. This is a young woman I interviewed in France. Tomorrow you will hear more about these kinds of practices and different ideas to avoid these types of practices. Because I think we can all admit that this result is definitely not care and not positive for humanity. Here is a statement a little less well known made by Danius Purus again at the time he presented the report I mentioned about this power imbalance and the crisis of societal obstacles that hinder individual rights. Power and decision-making in mental health policy, services, and care structures is concentrated in the hands of biomedical gatekeepers, particularly biological psychiatry. These gatekeepers, reinforced by the pharmaceutical industry, maintain this power based on 2 outdated and scientifically unsound concepts: that people experiencing mental distress and diagnosed with mental disorders are dangerous, and that biomedical interventions in most cases are medically necessary. These concepts perpetuate stigma and discrimination, as well as practices of coercion that are widely accepted in mental health systems today. I see the global state of mental health care not as a crisis of chemical imbalances, but a crisis of power imbalances, requiring urgent policy responses to address the social determinants of mental health, as well as the reflection of powerful stakeholders on their role in perpetuating an abusive status quo. In other words, the crisis in the field of mental health should be managed not as a crisis of individuals' conditions or disorders, but a crisis of societal obstacles that hinder individual rights. Another report that interests us is from the UN High Commissioner for Human Rights on Mental Health and Human Rights. It recognizes that in certain situations, the will of the person might be difficult to determine, as was said by the previous speaker. Therefore, we should encourage the use of advanced directives, the prevention of misunderstanding or arbitrariness by those executing them, with the right to modify at any time your will and directives, and the prohibition under Article 12 of resorting to the principle of best interests. He explains that where all means have been exhausted and the individual's will remains undetermined, the principle of the best interpretation of will and preferences of the individual must be upheld and carried out in good faith. He also calls for the effective remedies and redress for victims of involuntary commitment, including its imposition as a threat, as is the case for community treatment orders. And this is exactly where work is definitely needed, because even after certain reforms and changes in mentalities, we see many hurdles with practical implementation. And resources are lacking to support people to exercise their rights. This can result in de facto guardianship by family members. And this is particularly concerning as sometimes previous family trauma can lead to an unwillingness to communicate with your family members. Recent partial reforms, such as the right to vote when under guardianship in France and in Romania, are not always implemented due to the lack of support for people in institutions. Real supporters with universal design should be available for anyone with difficulties and integrated into community services, ensuring not only physical accessibility, but support for understanding information. Often, persons under guardianship do not even know that their signature is required, and they're not even asked for it, and they do not even always appear in court when measures of guardianship or community treatment orders are renewed against them, as they are simply considered unfit or incapable. Everyone needs and should be entitled to support for decision-making. So often, the bar is placed much higher for persons in vulnerable situations and with disabilities, asked to provide their entire life plan. The standard becomes higher due to fear and the idea of a need for protection. On a positive note, during a recent visit to support Girona in Catalonia, thanks to the support of Mental Health Europe, we witnessed some very promising and good practices and in these types of support services after reforms in Catalonia and Spain. It demonstrates that solutions are possible, and several representatives from this organization, Support Girona, are here with us today. So, to sum up, INU's position: depriving persons of legal capacity on the basis of a psychosocial disability and a psychiatric diagnosis leading to forced psychiatric interventions is not care, does not result in well-being. It disables care. It undermines the care relation. It does not result in safety. It results in more struggle, more crisis, and more risks. It indicates the deficiency and failure of mental health care with no adequate support in crisis. Forced psychiatric interventions enable neglect and undermine development of good support practices. They are not evidence-based or recovery-oriented, but remnants of the past. They are not protection, but are abuse. And they are not a solution, but a problem. Real and acceptable mental health care and support are possible when efforts are made. Many options are available between last resort and no care. Supportive interventions, for example, demedicalized, dejudicialized, crisis support and response to conflict, de-escalation, and responding to violence, particularly with peers. Decision-making support for personal crisis. And in prevention, we need to democratize knowledge, get people, such as in today's session, to know about this. We need to build and strengthen our communities for community accountability, support, acceptance, I'd say as well, and perhaps use the social and solidarity economy to do so. We need real development of mental health care and support based on equality and the person's will and preferences. This is urgently needed. So in conclusion, users and ex-users of survivors of psychiatry, such as myself and others here, are experts by experience, and we must play a vital role together in ending this imbalance of power. Services and legislation must be based on free and informed consent, without coercion or substitution of the right to decide on one's own life, in accordance with the Convention. An obvious challenge, of course, for our healthcare systems, social services, and our criminal law regimes. We need human and financial investment in these areas. It's absolutely essential. So the United Nations Convention on the Rights of Persons with Disabilities calls for a change of paradigm long demanded by persons with psychosocial disabilities who have experienced deprivation of liberty, capacity, forced treatment, guardianship, and institutionalization. We must share and learn from each other and from our experiences to reach these international human rights standards for everyone in Europe and the world. Finally, I wanted to leave you with Inus's vision of the future in this meme from one of our members. Maybe you can take a look. It is the idea that, and it's dated now from 2017, that there would someday be a museum for crimes against humanity, and restraint would be totally prohibited. Thank you.
Thank you very much. All this.
Thank you so much. We have finished almost on time.
Job. Varbūt kādi jautājumi?
Do we have any questions from the audience before we leave for a break? You are welcome.
At the moment, thank you very much for your excellent presentations and point of view. And we will see after 30 minutes for next session. Thank you very much.
Godātie viesi, es aicinu ieņemt.
Dear guests, I invite you to take our seats back so that we could continue with the second session of our symposium. Our session will be devoted to human rights and autonomy in mental health care. And Jernai Turin, chair of EHNRE Working Group on the Convention on the Rights of Persons with Disabilities, is invited for moderating our session. Ms. Boglarka Benko, lawyer at the European Court of Human Rights, is invited to the floor as well. A member of the CPT, researcher at the University of Latvia, Ms. Marie Amos, is invited. Jorge Araya, secretary of the UN CRPD committee. And Professor will join us online, and Dr. Oliver Lewis, barrister at Doughty Street Chambers, London. Welcome.
Welcome to the session on human rights and autonomy in mental health care. We'll have an opportunity to hear from Ms. Bolgarka Benko, a lawyer at the European Court of Human Rights, on protection of autonomy and personal freedom of expression of persons with mental disability in the case of law of the European Court of Human Rights. This will be followed by the member of the European Committee for the Prevention of Torture and Inhuman and Degrading Treatment and Punishment, Ms. Marie Amos, who will tell us about observations regarding autonomy in mental health institutions. And then we'll be hearing from Jorge Araya, Secretary of the UN CRPD Committee on Autonomy of Persons with Psychosocial Disabilities in Healthcare. And lastly, yeah, he's coming. You're here. Oliver is here. So Jorge Araya is not arriving. I didn't. Oh, it's over there. Hello. I didn't hear the Latvian version before. Sorry. Hi, Jorge. And Dr. Oliver Lewis, who is a barrister from the UK and a professor of law and social justice from University of Leeds, will discuss future directions of mental health law in Europe. And in the end, after their presentations, there will be time for discussions, an opportunity for you to ask questions. Ms. Bolgarka, go ahead. The floor is yours. Thank you.
Thank you. Good afternoon, ladies and gentlemen, and thank you very much for the possibility to present today the approach of the European Court of Human Rights on personal autonomy. Before doing that, I would like to present a bit what the European Court of Human Rights is doing in the aspects of persons with disabilities, because we are not only dealing with individual applications lodged against different member states of the Council of Europe, but we have quite a strong outreach program to share knowledge about the work of the European Court of Human Rights. And we have 2 online courses that are dedicated to persons with disabilities, and one is on bioethics. And besides that, we have a knowledge sharing platform that includes different guidebooks and handbooks on the rights of persons with disabilities from various aspects, from the right to vote, deprivation of liberty, or access to health care. And next year, we're going to publish a comprehensive guidebook on the case law of the European Court of Human Rights, which is going to englobe everything that we have ever done in the field of the rights of persons with disabilities. And as I said today, I would like to discuss how the European Court of Human Rights is approaching the issues of autonomy and personal freedom and independence. And it will necessarily include some kind of historical approach as well. And And before going into very much the details, I would like to remind you of the normative background of the court's work and the relevant provisions of the European Convention on Human Rights and Fundamental Freedoms. And if you remember, in the first panel, you had the chance to read Article 3 of the CRPD. And if you compare the provisions of the convention, you will find that there is no mentioning of the right to autonomy or independence, not alone for persons with disabilities, but for anybody. So this is the legislative background that we are dealing with. It enshrines rights, but doesn't mention the right to autonomy or independence. And another important aspect that I would like to mention that is particular for the convention system as such, that the court interprets its role as monitoring or scrutinizing how states restrict rights of individuals. But in comparison, for example, the system under the CRPD, the court is not really giving guidance how to fulfill those rights with content. We interpreted our role for quite some years in a way that we have to scrutinize, not to allow states to restrict rights, but we were not really encouraging or giving guidance to states what kind of extra measures or positive measures states should make or take to fulfill those rights with content. And this has been changed, and I'm going to discuss this to some extent. Now, if you take those legal provisions as a starting point, the question is that as a court implementing the law, how are we going to deal with situations which are not necessarily restricting rights of persons with disabilities or persons with intellectual or psychosocial disabilities per se. Let it be legal provisions, measures, or simply situations that are not targeting restrictions per se, but as their impact or their effect on persons with disabilities, they make the access to these rights impossible, or they make the independent exercise of these rights impossible. And the second question is, what are we going to do with situations where a person is complaining about a right that is not envisaged in the convention, that is not related to right to private life, or the prohibition of torture, or the right to private and family life, or the right to liberty, or the prohibition of discrimination? When somebody is complaining about a situation of restriction of personhood or the deprivation of personhood, which is not a right enlisted in the convention. And to reply to these questions, the court tried to interpret for itself or answer the question, is there something like the right to self-determination? Is there an additional right in the convention that is something that we can interpret as the right to self-determination? Or how shall we interpret the conventional rights to be able to respect the autonomy of persons with disabilities? And there are two lines of case law that dealt with this question, and this has also been discussed a bit in the first panel. The one is what we call the personal integrity of persons with disabilities, and the second one is the participation in society of persons with disabilities. And under these two lines of case law, the court has emphasized that if we understand that the basic principle of the convention is human dignity and human freedom, then we must also agree to the fact that it necessarily includes the freedom to make one's own choices. And the court emphasized that the right to private life or the right to life necessarily includes physical and social integrity, and the physical and psychological integrity. And if we have this as our basic understanding, then we also have to accept or interpret these rights in a way that they encourage persons of autonomous living or independent living, as we call it. And this, when it comes to decisions about physical and psychological integrity of the person, but also when it comes to decisions of participation in society, which all includes necessarily education or the right to vote or the accessibility of facilities in the society. And the court has emphasized that if we interpret these rights in a way that these rights are meant to fulfill our feeling of self-respect and dignity, then the restriction of these rights can lead to humiliation and distress, and the infringement of autonomy. So the court doesn't necessarily say that there is a right to self-determination, but emphasizes that every right under the convention should be interpreted with the understanding of that the underlying idea is that of personal dignity and freedom, which includes autonomy. And the cases that we are dealing with, which I would say that the barriers to personal autonomy are various. Some of them are really just based on legal provisions of member states, which we usually call as the legislative stereotyping of persons with disabilities, in particular persons with intellectual or psychosocial disabilities. We also sometimes refer to these situations as the historical discrimination, where simply the legislative provisions have a presumption about the capacities of persons with disabilities without the evaluation or the actual evaluation of the capacity, and deprives persons with disabilities without an individualized analysis of their capacities and also of their needs. And I would like to emphasize this second element. These are mostly legislative provisions concerning the right to vote or a certain educational rights. It has been discussed a lot, the second element that I have included in my presentation in the previous panel, and the issues of substitute decision-making or the deprivation of persons with intellectual or psychosocial disability of decision-making altogether. And I think this has been very well described in the previous presentation. I would just like to emphasize one element here of our interpretation of informed consent in access to medical healthcare, and how the court is trying to overcome this issue of transferring decision-making in healthcare, and what exactly informed consent is making. And I think the difficulties in that respect has also been discussed to quite a big detail in the morning. The third element of our case law, or the group of cases that we are dealing with, are the issues of institutionalization. And I distinguish this from the deprivation of liberty, because we are dealing with cases that institutionalization of persons with disabilities in nursing homes and healthcare facilities without judicial decisions of deprivation of liberty. And the court emphasizes to a great extent that institutionalization often leads to the de facto restriction of other rights of persons with disabilities. So it's not necessarily the personal freedom that is at stake only, but other rights as well. And therefore, it creates a dependency on an institution or a guardian in some situations that the court is scrutinizing under the convention. And the final element that I think I need to mention is obviously the questions of deprivation of liberty. And in the previous panel, it has been mentioned what are the difficulties with the court's case law in the sense that the convention allows for the deprivation of liberty of persons of unsound mind. But the important development, what I would like to put forward for you to consider, is how the court interprets deprivation of liberty and emphasizes the subjective element of deprivation of liberty, that it's the individual's conception that is a constituent element of the question whether somebody has been deprived of his or her liberty. And another element that we take into consideration is the question whether deprivation of liberty automatically leads to other restrictions of rights, especially the right to decide about one's health, and the question whether deprivation of liberty can automatically lead to, for example, forced treatment of persons with disabilities. And when we are dealing with these questions, and as I already said, there will be a historical element of my presentation, I would need to highlight the change or the development of our case law, how we constructed these or how we dealt with these issues previously and what we are trying to achieve now. And the old understanding, what it means to protect rights, was that the court is there and the state authorities are there to protect the individual's interest. Let it be financial interest, and let it be health interest or personal interest. And this has been also raised in the previous presentations. What does it mean, somebody's interests? It has to be in compliance with the values of society, but the understanding was that there are people's interests that has to be protected. which usually or quite often took the form of taking the autonomy of the person away and giving it to a third person. And what protection in these circumstances meant that there are safeguards included in the system to prevent abuse in this substituted decision-making. And an additional element which unfortunately we cannot overlook, that for quite some time reflecting or mirroring the legislation of member states of the Council of Europe, protection also meant the protection of society. It also meant that states are allowed or justified to restrict certain rights of persons with disabilities to ensure that only persons with required level of mental skills participate, for example, in political decision-making. Or if you think about what we call mentally ill offenders and the protection of society from eventual harm. And where I see that there is a development in our approach and in our case law, and this has been largely motivated by the Convention on the Rights of Persons with Disabilities, is the new function of protection. That we understand that protection means to protect the individual's dignity and self-determination and autonomy. And protection means that support should not lead to undermining the person, and there should be adequate safeguards in this support. Now, taking these two elements or these two ways of interpreting protection of rights, I try to summarize for you what exactly the court is considering as obligation on member states or obligation on national authorities when they are dealing with persons with disabilities and the questions of autonomy. And this, I would like to start with what has already, I think, has been discussed in respect of England and Wales, that for quite some time our case law was busy with assessing the cognitive ability of a person and whether domestic authorities carried out a proper assessment of the cognitive ability of a person. That the understanding was that disability affects cognitive skills and rendering individuals unable to adequately understand the significance and implications of a specific decision or the lack of ability to administer their affairs. Unfortunately, it sometimes also meant the restriction of rights because the individual was unable to express a coherent view. And as I said, we were busy scrutinizing whether the person with disability had what we call a true mental disorder. And so this was a very medical approach to personhood. And in addition, the development of the case law went in the way that probably has also been covered in the previous panel, that the court understood that the capacity, the function of a person has to be assessed on a case-by-case basis, the assess capacity function by function. So we obliged domestic authorities, especially courts, when restricting rights concerning autonomy, exercise of autonomy, to explain exactly what kind of actions an applicant is unable to understand or control, and whether a disability has really any consequence on social life, has pecuniary interest, and so on. As I said, it still allows for the restriction of certain rights based on a mental disorder, but only if it is a kind of degree warranting for that restriction. And ensuing obligation from this is that whatever solution a state introduces as supportive decision-making, but mostly substituted decision-making, has to be tailor-made. And the persons can be divested of legal capacity or decision-making if it is an adequate answer to the situation. And provisions of care should not necessarily and immediately entail the deprivation of legal capacity. A very important element of our case law, and unfortunately it has not really been used to allow a criticism towards our staff, is the consideration which I think was also pointed out in respect of the jurisprudence of England and Wales, is the question that is there other less restrictive measure that is capable to serve the same purpose? So in theory, states should demonstrate that they tried everything else before they have recourse to the restriction of rights. And as I said, these kind of obligations correspond very well to the understanding that that protection means protecting the individual's interest. And it very much corresponds to the old approach to protection. and to the fact that the court interpreted its role for quite some time in a way that we only have to scrutinize to what extent and in which way governments are restricting rights of persons with disabilities. Now, if we depart from that and we understand that the protection of rights actually mean the protection of autonomy and independence of a person with disability, then these kind of measures are not sufficient and actually have an effect to the contrary. So what we are emphasizing now, and I think this is quite difficult to do, is the issue of striking a fair balance, because it has also been raised in the previous panel as well, that we need not to forget that under the convention, the states have not only an obligation to preserve autonomy or protect autonomy, but they also have a number of other obligations, including the preservation of health, mental health, the preservation of life. And what we are trying to achieve is the demonstration that state authorities can strike a fair balance between these two, that the right to dignity and self-determination can go hand in hand with the protection of an individual's interest or the protection of an individual's health. But we expect member states to demonstrate that a fair balance has been struck. This, until recent years, only meant that when domestic decision-making was to take into account a person's will or preferences, which probably falls short to the obligation to respect the preferences and the will of a person concerned. The second element, what we trying to achieve, and this is what has been called in the previous panel as creating an environment that respects autonomy, which I would say facilitating autonomy. So to facilitate, first of all, to facilitate the participation of disabled persons in the life of the community with the very reason to prevent isolation and segregation. And this includes the facilitation of access to rights, for example, in education or in the exercise of the right to vote, with the idea of to prevent marginalization. But most importantly, it means to introduce legislative safeguards and mechanisms that support persons with disabilities to express their will, or in medical terms, to express their valid and fully informed consent. So it's the obligation, a legislative obligation on states to introduce safeguards of supportive measures instead of restricting autonomy. And the final thought that I would like to mention today, and is the dilemma that we are facing when we are trying to apply these concepts in our case law. And the case that I included in my last slide is coming from Portugal, and the question how much the right to the obligation of states to preserve or protect the life of a person is in conflict with the obligation of the state in certain situations to protect the personal autonomy of a person with intellectual or mental disability. And this case concerned a question lodged by the parents of a deceased person who was released from psychiatric care and committed suicide right afterwards. And the argument of the parents were that the state should have been, or the domestic healthcare providers should have restricted the liberty of that person to not to allow him to self-harm or commit suicide. And when the court dealt with that question, it said that even if the state has this obligation to respect and protect the life of a person and to introduce protective measures in that sense, it should only do it without infringing personal autonomy, which is a very far-reaching final thought. But in this present case, the court found that releasing that applicant from psychiatric care was in respect of his autonomy, and in that sense found that the state has not violated the right to respect for private life by allowing the person to make decisions for himself. Thank you very much. I think if there are questions at the end, right?
Thank you, Ms. Benko. We are now moving to the presentation of Ms. Amos on the CPT's observations.
Sorry, how to, yeah. Until the PowerPoint is put up, and I try to mingle with the several computers here. So again, my name is Mari Amos. I'm the member of the CPT, also part-time researcher in this very building here. Formerly, I served my two terms in the SPT, that is the similar type of a committee in the United Nations. Yep, thank you. I'm here in my capacity as the CPT member to present some observations about the autonomy in the mental health care and specifically institutions, what the CPT has observed. When I started to prepare for my today's presentation, and I will be very schematic because honestly speaking, the CPT has been operating for more than 30 years already, so you can imagine that the jurisprudence is pretty vast. So I'll just highlight the most important cornerstones. But in any case, when I started to prepare and search for the autonomy, specifically in the mental health institutions, so not that I found much about the autonomy in decision-making that I wanted to speak about and that I will speak about, but mostly when, you put the Control F, you start to find autonomy. What you find in mental health institutions is more or less independently going to toilet, so being autonomously able to go to toilet. I hope that in the future, this pattern would change, that we would also in the CPT concentrate more on this personal autonomy of decision-making, of this, the way how people are able to shape their lives, not only that they are able to go to toilet alone or to be outside of the institution. So, in any case, my presentation is divided more or less into two parts. Firstly, I will very shortly give you the overview of the standards that the CPT is applying. And then secondly, I will give you a short overview about the jurisprudence from the visit reports. I need to mention, I need to find the button. I need to mention, as you can see now from the headline yourself, that the CPT standard that is most relevant on the issue is pretty old, meaning that also in a moral sense it is somewhat outdated. And I'm totally hopeful that in a closest future we're able to update it in according to current standards. And I here need to mention that the Latvian CPT member Solvita, who is sitting here in the first row, is one of the loudest supporters of the idea that we definitely need to update also our thinking and jurisprudence in the CPT. But the report refers back to one of the standard, referring back one of the earlier standards that sets the groundwork for the healthcare services in prison, and also states regarding the psychiatric establishments that definitely, the basis of people who are treated in the psychiatric establishment should be ideally the free and informed consent to treatment. And all the patients who are in the institutions, they should be in a position to give their free and informed consent to treatment. Underlining here again that when you are put into the institution involuntarily, it does not mean that you can be also treated against your will. Already in this early age, so to speak, separating these two notions, at least something, and if the state really feels that there are certain occasions when persons should be stripped from these rights, these occasions should be based only on law, and these should be really, really exceptional. And of course, if we speak about the informed consent, it can be based only on the information. The information should be full, accurate, and comprehensive about the condition and treatment that is proposed. And this information should be proactively provided to the patient or the future patient, let's say. Not that people who need or want to have treatment should be actively seeking for such information. So this is like the total groundwork, the basis, how the CPT goes about the issue of patient in relation the institution where he or she is cured. Document that is quite old. Now, the jurisprudence from the CPT visit reports. And the first is legislative basis. But before I go into this topic, like I told you, the CPT has been operating for more than 30 years. So some of the things, they are well-established jurisprudence, like it said in the CPT, meaning that it's already old jurisprudence. But fortunately, we have been slowly updating also some of our thinking, and here I underline really the groundworks, but also highlight some of the places we have been managed already to update that more reflect to the current thinking about the personal autonomy. So the legislative basis, in any case, there should be, first of all, clearly the legislative basis determining the patient's or person's autonomy when they are in the hospitals, voluntarily or involuntarily. But clearly, if person is in the institution on involuntary basis, the legal basis should be really particular, really clear, and really strong. And for that, the countries that we foresee should have a very clear mental health law, and the mental health law should then stipulate these things that you see there on the slide, meaning that exact procedures, how to put the people against their will into the institutions. Secondly, patients' rights to appeal against all the interventions that are committed against their will. Also, that there should be procedures for revision in certain after certain intervals of the condition of person. Legal aid should be provided to the persons. Also, there should be safeguards on place. The use of restraints should be regulated on a law basis. And also, complaints procedures and external supervision should be granted. Consent to treatment. So clearly, there should be appropriate rules in every psychiatric hospital. I mean, also countrywide, but also in every hospital. How does it happen when person should be treated against the person's will, and how person should be treated when there is a will? So, what are the proceedings to really grant these basic rights, like the consent, information, and so on and so forth? Again, we underline that there should be consent for both, for placement, I mean, for the fact that person is in the hospital, and secondly, that person is agreeing to all the interventions that are done in a hospital to this person. And it is underlined in different visit reports to different countries that the fact that the person is put in the hospital or the person voluntarily comes to the hospital does not mean automatically that the person has also signed that I'm really willing to take everything that is offered in this particular institution, please to perform as you will. It's not like this. And also, in some of the cases, what we have been is that clearly it is more convenient, specifically from the administrative point of view, to have all voluntary patients. So even if a person objects in principle, or if you see that there are conditions when there is a question that perhaps this person should be going through the independent procedures that would authorize the involuntary interventions, the personnel of the institution still is persuading or tricking the person to undersign the consent to treatment form, so they don't have to go through all the administrative hassles. This is, of course, I mean, not acceptable, clearly. And continuously, the person's situation should be reviewed, and the person who is under involuntary treatment or involuntary placement should be constantly reminded of their rights to appeal, and these who are on their voluntary basis in institutions, they are also should be reminded their right to more or less leave or to terminate the treatments. So the patients should be having an understanding that they are the masters of this contract to treatment. In reality, clearly what you can see in many occasions is that person goes to the hospital, wants to have a treatment. So the person is diagnosed, put to the closed ward. The person is on voluntary basis. The person wants to leave and leaves. What happens is that the proceedings are launched, police is called, person is caught, brought back to the closed ward and stays there. Well, not really legal. Obligation to inform. So clearly, I mean, all the consent can be legal only when it's based on this full, clear, and accurate information. What does it mean? It means that the patient should be informed, first of all, of the condition. What is the thing that needs to be cured, so to speak? Of course, of the treatment that is proposed, and also the side effects. That is really important and on many occasions totally neglected. And the third element, like I told you, possibility to withdraw the consent that is given. And also, it should be evaluated on the moment when all this information is done. Is the person actually able to give the consent, or is the person not able to give the consent? To make things clearer, I think in all the reports that the CPT is issuing and dealing with the mental health issues, in all the reports we underline that there should be clear brochure stating the rights, all the safeguards applicable, issued to every single patient, does not matter of the legal status, also in a language that is understood easily, not in this 0.8 small letters, but in this also like visually accessible format in different languages given the potential patients. And in case the patient is at the moment still not able to quite understand what is there in the brochure, the person should be able to get constantly help in understanding the content of this brochure. It's not there in many of the countries, but we keep on pushing that such rights in written format should be available for patients all the time as well. So, recording of consent. This is also one of the overarching requirements, that there is a need to properly record the patient's consent. And for that, in all the institutions, there should be such a clear consent form elaborated that the patients then should read, understand. If not, they should get help and then sign. And also they should be reminded, like continuously, like I said, that they have the right to withdraw also this written consent that they have signed. Now, it's complicated and a challenging issue, of course. Patients under guardianship. So on many years, decades rather, it was like clear, like if a person goes to the institution, wants to get help, he or she will consent. If a person who is under the guardianship goes or is brought to the institution, then honestly speaking, does not matter what the person is saying, but matters what the guardian is saying. The guardian is saying, please treat the person, and then the treatment has started on voluntary basis because the person, the guardian has signed to it. But now, fortunately, a few years ago, we started to change this jurisprudence. And now our new standard, so to speak, is that if a person goes to the hospital or in whatever stage the person under guardianship starts to oppose the treatment or the placement, then immediately the involuntary placement, in case the treatment is still needed, should be started, and then the court should evaluate if it's really needed or not needed, despite of the fact what the guardian is saying. So that's, I think, for the CPT is already a major step forward. And also, the CPT has recommended to a couple of countries that ideally also the psychiatric hospitals should have access to the information, the statewide information, who has the guardianship, who has been limited of their legal capacity, to be able to understand if person comes to the institution or is brought to the institution, I mean, how to legally go about the situation. Admittedly, this might be difficult to achieve, especially in some countries that are not very digitalized, but in any case, I'm just highlighting that this is something that we have been deciding. And then a couple of additional issues, research and trials. This is very sensitive. Also, do this CD Bio, who is sitting here, I mean, this is a very sensitive thing. On many cases, of course, it is a great attempt to perform more sort of clinical trials on the patients that are in a psychiatric hospital, especially if they are there long-term, because they are easily reachable, so to speak. So in that case, on number of reports also, we have highlighted that in case, if there is such a will, then of course you can only perform it if there is like a free, totally informed consent from all the participants in such a trial groups, and you have to make sure that when you get this consent, these people are actually able to understand what will be going on, what could be the side effects, and that they are really having the capacity to consent to it. First here. Secondly, we have been underlining that these committees or supervisory authorities in the member states, they should be also able in the long run to evaluate if such a trials and researches that are performed in mental health institutions, if they actually have been based on this informed consent. How to do it, honestly, I don't know. How to, in a long time, I mean, when looking back prospectively, a couple of years, how would you understand, I mean, what was going on in this situation? But it is very difficult to even to somehow foresee how would you legally perform the trials in such groups. And treatment plans, clearly, I mean, this is the place where it's absolutely the patient autonomy should be underlined, that all the patients, honestly speaking, does not matter what is their status in the particular institution. They should always be in a maximal way involved into drawing up their treatment plans and discussing them. So that's it. Very schematic, as I promised. But in any case, any of you would like to elaborate further, share their ideas or ask any more comments, as much as my confidentiality clause allows me to share it with you. Here you see my email address, so feel free to engage with me. Thank you very much.
Thank you for your presentation. So now we'll hear from Mr. Aroa, who is with us online.
Yes, thank you. I hope that you can hear me clearly.
Yeah.
Yeah?
Not yet.
Not yet?
Oh, here you are.
Okay.
Go ahead.
So thank you so much. If there is any problem with the microphone, please just send me a message in the chat box so I can control the if I still have, let's say, like access to the meeting. So I really I was listening carefully all the previous interventions, and I'm really acknowledged that the court, at the regional level, has made significant efforts to interpret the convention in a more progressive way. Remember that the European Convention, is from the 50s. So, but let me just say a few words about the United Nations Convention on the Rights of Persons with Disabilities. I'm the secretary of the Committee on the Rights of Persons with Disabilities, which is the main body established by this convention to interpret the convention. So, I was assigned the task of, briefing you about the issue of autonomy of persons with disabilities, and particularly persons with psychosocial disabilities in the UN CRPD. So you will observe that the standards that the convention has established are quite different from, the standards at the regional level. So there is a shift, no, of course, in the way in which persons with disabilities should be treated. Let me just let's say, like, mention that the UNCRPD Convention, it's a widely accepted, legally binding treaty across the United Nations, and then we have right now 188 states parties to the convention, which is means that the convention is almost a universally ratified treaty. And in Western and Eastern Europe has been ratified by all countries except Liechtenstein, which I understand it's about to ratify soon. So let me just, put it in a clear way so that you can understand better what is the shift. Of course, you probably, I was not here in the morning, I couldn't, but probably you have heard that, the convention introduces a shift of paradigm about persons with disabilities from from medical model, charity model, to social model and human rights model of disability. So this is very important because this has significant consequences when it comes to the matter that we are discussing. So let me just put it in this way. The Convention on the Rights of Persons with Disabilities does not explore, for example, and I'm using, notions that are familiar with you, either restrictions on the rights, if there could be restrictions on the rights of persons with disabilities, established on their best interest for the sake of their protection. So this is a more traditional approach, whether or not there would be, let's say, some restrictions, in the best interest of persons with disabilities for their protection. But this is not the model. This is not really consistent with the convention. In the case of the convention, we need to really understand it in a different way. And the way is very simple, but has a lot of consequences. So instead of trying to figure out whether or not some restrictions to the rights of people with disabilities could be established on their best interests or on their protection, so the relevant assertion is that there should be no restrictions on the rights of persons with disabilities based on impairment. So you see that there is a very, very radical shift here. So in principle, there should be no restrictions on the rights of persons with disabilities based on impairments. So we are not looking into the best interests of persons with disabilities. So we are looking into the respect of their autonomy, will, and preference. So this is a very, very radical shift when it comes to the convention. So we are no longer, looking into their best interest or the interest of their protection. We are looking into the respect of their will, preferences, and autonomy. And then, of course, the question is not about the protection of persons with disabilities. No, the convention is not about the protection of persons with disabilities in the sense that they could harm themselves or be harmful to others. No, this is not about the convention. The convention is about the protection of the rights of persons with disabilities, which is quite different. I have heard about, say, how at the regional level there are different laws and practices still providing for guardianship, institutionalization, coercion in mental health, etc. And the committee is aware of these practices because, of course, until now, the committee has reviewed more than 100 state parties' reports under the Commission, including reports of all the countries that I imagine are present in the auditorium, let's say. So what is we should be clear about this convention. So guardianship or subjection to guardianship is not allowed in the convention. It's not a measure of protection of persons with disabilities. Institutionalization and voluntary institutionalization is not in line with the convention. It's not a form of protection of the rights of persons with disabilities. It's indeed, doing harm. Because there's overwhelming evidence that institutionalization has, let's say, done harm on persons with disabilities. And of course, coercion in medical settings is not a form of protection of the rights of persons with disabilities. So I'm saying this from the outset so that it's clear that under the convention, we should think out of the box. We should change our way of thinking. This is not to say that the, regional standards, are probably, let's say, like, okay or not. We're not, looking into regional standards. We're looking about universal standards that are applicable to countries that have ratified the conventions. So, of course, this is a matter for legal interpretation for those lawyers, that need to look into which standards is more progressive, et cetera, et cetera. But here, what I'm trying to really convey is that, all these, old approaches, need to change, with the entry into force of the convention. Let me just be more specific because you have touched upon many things, But I wanted to be short as well, not to overwhelm you because, otherwise, this would be without purpose. Of course, the convention particularly specifies, at least in three, provisions, and in the preamble, the issue of autonomy of person with disabilities, all persons with disabilities, including persons with psychosocial disabilities. I will, let's say, concentrate my efforts in three provisions, or even fourth or fifth provisions. First of all, Article 25D of the Convention, which relates to the provision of or the rights to health, establishes that the provision of health care should be of the same quality to persons with disabilities on the basis of their free and informed consent, and oblige state parties to ensure that health care providers, including mental health care providers, are aware of the human rights of persons with disabilities, their dignity, and their autonomy, and of course about their requirements. So this is something that, of course, I insist that needs to happen, because we have seen that in many states there is still, let's say, like voices, especially in some mental health settings, that are still advocating for coercion, institutionalization, etc. So I think that that's very important. There is a clear understanding in the convention that all treatments and medical treatment and every provision of health and mental health should be based on the principle of free and informed consent. The preamble of the convention, of course, is quite clear about the fact that individual autonomy should be respected, and this includes, of course, the freedom to make, by persons with disabilities, of course, make their own choices, and this is reinforced by Article 3 of the convention, which you have already heard in the morning about individual autonomy and the respect of freedom to make one's own choices. So I think that is quite clear, from the point of view of the UNCRPD Convention, that we need to rethink the way in which we have, let's say, set up these institutional arrangements, set up our interaction with persons with disabilities. When it comes to decision making, because we are talking here about autonomy, will, and preferences, and decision making has been repeatedly mentioned at this point, we should not forget that we cannot have two systems of support to persons with disabilities when it comes to decision making. Some countries are still, let's say, perpetuating the system of substituted decision making with some safeguards, and some countries are telling the committee that insofar they are reinforcing their safeguards, substituted decision making would be okay. Well, this is not accurate. This is not in line with the convention. So, a state should abandon the system of guardianship and substituted decision making, and this is, I'm so sorry to say that, but this is a legal obligation. So the convention imposes on a state party the duty to move away from substituted decision making and to include a system of supported decision making. So it's not about, increasing safeguards or, creating new safeguards, for protecting. No, it's about abandoning system of guardianship, abandoning system of decisions made by third parties, and restoring the autonomy, decision-making autonomy of persons with disabilities. And the claim is that, this is risky because this is something that will leave them unprotected. But in fact, no, it's in line with the human rights matter. In so far you are depriving someone from their autonomy to make decisions, this is not really a right holder. So I think that we need to think about how we are doing. There is legal reform. Recently, some countries in the region have adopted, modified their civil codes. There are procedural codes as well, civil procedural codes, and then have, let's say, adopted provisions that appear to go in the right direction on eliminating barriers to decision making. But clearly, when we're talking about decision making, and this is my next point, is that there's still legislation and practices that are confusing the mental capacity and legal capacity. And this is something that has been for decades, in the legal practice, but also in the medical practice. So what is interesting here is that the convention is asking everyone, to make this distinction. If you are depriving, someone of their legal capacity on the basis of diminished mental capacity, you are basically depriving legal capacity on the basis of impairment, which is discriminatory. So that's very important to bear in mind. In so far you continue depriving legal capacity on ground of mental capacity, that may amount to discrimination on the basis of impairment. So discrimination is prohibited in the convention. So I think that is a challenge here. It is possible. I think that parliaments, legislators in several countries have understood this, and have moved forward to a system of supported decision making. And the abandonment of this, let's say, conflation between mental capacity, decisions to understand things, and legal capacity. And this brings us, and this is my last really point, about, let's say, the assumption that persons with disabilities, and particular persons with disabilities, can develop crises, based on their impairments, and can be, let's say, like harmful to them or to others, which of course has been repeatedly invoked to the committee to make exceptions for supported decision making, or exceptions for the prohibition of involuntary institutionalization or coercion. So this is still, say, something areas that resist, the principle that we should respect autonomy, will and preference of persons with disabilities. They are human rights. And this is quite critical when it comes to crisis, when we are talking about crisis. But maybe allow me to distinguish between two different, arguments that have been used so far, to, continue justifying these, let's say, practices that are harmful to persons with disabilities. The first one is the fact that there are life-threatening situations, like, crises in which our life could be threatened. But then, these discussions are not really taking into account that everyone can experience a life-threatening situation in which, for example, someone, because of an accident, falls in coma, etc. So I think the principle here is for whatever protocol you, introduce for facing life-threatening situation should not discriminate against persons with disabilities. It should be applicable to everyone without any sort of discrimination. So if you, and this has been discussed, for example, the other day I was listening to a protocol that has been developed in Spain, for, let's say, being applicable to persons with disabilities, but in life-threatening situation. But I think that we need to think out of the box here as well. You cannot, let's say, like just legislate only for persons with disabilities in life-threatening situations. whatever solution should be applicable to all persons with or without disabilities. And then the other thing that, I mean, is coming so frequently to the committee from countries in the region is this idea that sometimes in the best interest of persons with disabilities, when they are, particularly persons with psychosocial disabilities, when their best interest is, is in the best interest to protect them, and then they are experiencing crisis, and then coercion comes in automatically in the force of police enforcement intervention, of medical intervention, of forced treatment, etc., etc. And this is something that, I mean, is still entrenched in many, I mean, minds, that, I mean, we should, let's say, like, I mean, stick to the paradigm of best interest. However, I mean, we should abandon this paradigm. Sorry to say that. I mean, if we accept, that we have a legal obligation under Article 12 of respect the autonomy, will, and preferences and decisions making with this of persons with disabilities, we accept, that the lack of mental capacity does not justify the deprivation of legal capacity, then we should change our paradigm of from the best interest of the person to the best interpretation of the will and preferences of the person. So this is a new paradigm, the best interpretation of will and preferences of the person, which is in line with, let's say, so when you have this crisis, I mean, probably someone that become agitated, because of whatever situation, you need to respect these rights, So I think that we are not talking about dreams, we're not talking about, no, we're talking about legal standards that need to be interpreted and need to be changed. And of course, I mean, practices at the national level will also need to change. I will finish my intervention because, of course, I mean, I'm aware of time, but let's say inviting you, I mean, to read carefully the jurisprudence of the Committee on the Rights of Persons with Disabilities, and that is a very interesting case. Probably you are very aware of this. It's the case of Vincent Lambert, and it's a case that, I mean, was widely discussed in France about a man that, I mean, was basically being fed through tubes, in a emergency unit at a hospital. And there was a legal battle, and then, of course, I mean, even the society was heavily divided, and then, of course, I mean, the case was brought to the attention of the highest jurisdictions in France, and then to European Court of Human Rights, and then, of course, it comes to the Committee on the Rights of Persons with Disabilities, and then the committee was seized by, I mean, parents or, I mean, relatives of Vincent Lambert, alleging that his right to life was violated because, I mean, he was disconnected from, I mean, all these machines that were supporting his life, So, and then the committee, and that's why I bring this case to your attention, was very clearly declared, I mean, the committee declared the inadmissibility of the case because it was clear from, I mean, the evidence that was in front of the committee that the will and preferences of Vincent Lambert was not to be connected, was not to be, let's say, like, I mean, have this kind of artificial life. So the committee basically found that, I mean, the authors of the communication, I mean, these relatives, didn't have any standing to represent the views and preferences of the victim, of the alleged victims. So in this case, the committee reinforced the understanding that, I mean, we should not, let's say, like, apply the best interest of persons with disabilities. We are not talking about the protection of persons with disabilities. We are talking about the protection of the rights of persons with disabilities. And we are talking about the best interpretation of their will, preferences, and autonomy. So I think that's, I hope that with this short presentation, that provoking you some sort of discussion. Of course, what I've said is not, let's say, like, well understood in many cases, but I think that it's important that you start, let's say, basically knowing more about the convention. It's a legal instrument. We are bound by the convention, all of us, that are present in this room. And then we need to really, I mean, make efforts to move forward and then to move into other discussions. For example, we should move to the discussion of what we should do to really establish a system of supported decision making. What should be, let's say, our way forward in terms of moving people out of institutions, and knowing that institutions is not a means of protection, what we need to do to end coercion in mental health settings, et cetera, et cetera. I think that that's the way forward, and I think that you are in the right path, and I really, congratulate the organizers of the symposium. I know that tomorrow there's a conference also on this issue. So I will stop there, and I would like to thank you, and of course, I will remain here a few minutes if there is any feedback or comments. Thank you so much. Over.
Thank you, Mr. Araya. So let's hear now on the future directions of mental health law in Europe. Dr. Lewis, the floor is yours.
Good afternoon. Thank you very much for inviting me to speak with you today. I'll try and be brief, but that's what all lawyers say. I'm a lawyer dealing with mental health and disability issues in the UK. So my cases involve people who are in psychiatric hospitals or social care institutions or settings, and they also involve deaths, such as the one that Boglaka was describing. And I still do some international disability work. But for the first 15 years of my professional life, I did only international disability law, and it was based in an NGO based in Budapest called the Mental Disability Advocacy Centre. We worked across many different countries in Central Eastern Europe. And in 2002, together with Yeva, who's sitting over there, the pioneer in Latvia of mental health law and disability rights, we jointly organized, I think it was the country's first seminar on the European Convention on Human Rights, as it applies to people with mental health issues or learning disabilities, with some funding from the Council of Europe. And that was one of the 10 countries that I went to in 2002, probably before some of you were even born. And Yeva was then at the Latvian Centre for Human Rights. I think we had around 10 or 15 people who attended that seminar. So coming back in 2023 and seeing so many people talking about human rights and the rights of persons with disabilities is amazing. And also to have a lawyer from the registry of the court was something we could not have expected back then. And Latvia obviously had not even joined the EU, there was no euro, and the CRPD was a sparkle in the eye of some very small amount of extravagant disability rights activists. And so it's nice to be back, and it feels a little bit like a reunion, because during 2002 we also went to Estonia, and that's, I think, when Mari and I first met each other, and also Gundega, who was also at the Ombudsman's office here. So what I'm going to talk about is I'm going to look back a little bit from those times and from our visits to hospitals the following year, and also look forward. So I'm going to talk about the compulsion end of mental health services, obviously acknowledging and recognizing the need to try out and implement alternatives. But it's obviously at the compulsion end of mental health services that there's a significant risk of human rights abuses. So first question, which I want to ask, is what's the point? What's the purpose of mental health law? So I think we have to be really brutally honest with ourselves and recognize that in the vast majority of countries, mental health laws do not provide a guide for governments about how to organise and run mental health services. They don't say anything about budgets and the need to shift budgets away from institutional settings and towards community support services. And they actually don't say anything generally about the sort of stuff that we've been hearing about that the CRPD promotes, including independent living. I would suggest that the thing that mental health laws do is make lawful that which would otherwise be unlawful. So it's generally against the law to take someone who hasn't committed a crime and lock them up, often for quite long periods. And it's usually against the law. It's usually a criminal offence, hopefully a criminal offence in all countries, to inject that person with chemicals that are intended to change how their mind thinks. And often those chemicals have impacts or side effects on their body as well as their mind. And so I'm not going to go into what the law in section 68 of the Latvian law says, or look at what Article 5(1)(e) of the European Convention on Human Rights say, but generally speaking, mental health laws set out the circumstances in which it becomes lawful to do those two things, to deprive someone of their liberty and put chemicals in their body, and other things like secluding them, physically restraining them, etc., etc. And so generally mental health laws talk about what is a mental disorder. They say something about the necessity of detention and treatment. They say something about the risk of harm to others and potentially about the availability of treatment as well. And so if the state, if a country gives the possibility that people will be locked up and forcibly treated against their will, then it makes sense for those things to happen in the narrowest possible cases, in the smallest number, narrowest possible circumstances, right? And so that's why mental health laws also contain details of what we call safeguards, or what I'm going to call elements of the rule of law. What are the elements of the rule of law that are injected, generally speaking, into mental health laws? Well, three really basic points. One is that the person has to be provided with information. Mary has talked about this. This is in the CPT rules. It's also in Article 5(2) of the European Convention on Human Rights. The reasons for the detention need to be explained, and the opportunities that the person has to do something about that. And the thing which they can do, but it shouldn't rely on the patient to do this, is for a court or a court-like body to review the lawfulness of the detention. That's set out in paragraph 4 of Article 5 of the European Convention. And although there's no requirement for a judge to be involved in the initial admission, there is, and I know that you have a 72-hour review here, which is going to be a kind of extraordinary scramble and urgent hearing, and I bet that very few people are discharged at the point of 72 hours. But the requirement under the convention is for there to be a periodic review for the reasons, the lawfulness of detention, and making sure that the statutory criteria exist. And within those court procedures, there's a requirement for the patient to have access to a lawyer. And there needs to be legal aid paid by the state for a trained lawyer to represent the person. And there's a great case from 1992, Medieri and Germany, which establishes essentially the right to legal assistance in mental health cases. And it said the court is basically saying it's pretty obvious why there needs to be legal assistance, because you've got someone whose personal liberty has been removed, and you might have someone who, I mean, if they are correctly detained, they will have a mental disorder. They use the term diminished mental capacity, which may or may not be true. But because of the combination of detention and some sort of mental disorder, obviously, the court says, the person needs access to a lawyer. So what I'm going to talk a little bit about what, because I know that there are lots of lawyers in the room and online, a little bit about what's required. And in doing so, just to flag, Article 13 of the CRPD talks about access to justice. That's not a concept that the European Convention on Human Rights uses, although the right to a fair trial in Article 6, which is imported from Article 6 into Red Cross, from Article 6 into Article 5.4 in these sort of mental health court systems. Access to justice is a similar concept. So Article 13 of the CRPD, but also to flag this really good document, Guidelines on Access to Justice for Persons with Disabilities from 2019. I'd like to go back and see how far we've come by using two examples, or examples of mental health services in the east of Latvia. And 20 years and 2 weeks ago, Yeva and I spent a lovely week together in a minibus, traveling around Latvia. There were some other people as well, including Danius Puris, who came. And we visited 3 psychiatric hospitals and 3 social care institutions in that week. And it was part of a Baltics-wide, including Kaliningrad, project. And I have a very vivid memory of visiting Daugavpils Psychiatric Hospital, where the director of the hospital told us very confidently that all of the patients there were voluntary patients. They all wanted to be there, and of course they could freely leave at any time. And so then after the kind of introduction part with her and her team, we then visited the wards, and we insisted that the staff remained out of earshot, and we spoke to the staff, and we saw the overcrowded rooms, often 11 or so beds in some of the dormitory-style rooms, and we talked with many patients, and none of them particularly wanted to be there. Some said they have nowhere else to go. They'd otherwise be street homeless. None really wanted to be there, and all would have left if they could have. Many didn't know that they could theoretically leave. That was news to them. So when we're thinking about information, the information to the patients was quite lacking, we observed. And there was a lack of activities. People were very medicated and also very bored. There was an institutional cycle, so people going back into the community and then very quickly coming back into hospital, or people stuck there because they were waiting for a placement in a social care institution. And you had this, essentially, a pretense of the voluntariness. So, you know, they were those who had signed, as Murray said, those who had signed the admission papers consenting to be there, had signed either because they didn't read it, they didn't understand it, or had signed under obvious duress. And so I was very struck when I read the report of the CPT, who visited in May last year, and their report came out in July this year. And they essentially observed pretty much the same thing as we had seen 20 years ago. And although they noted that Daugavpils has reduced the number of beds from 685 in the CPT's first visit in 2007 to 370 beds now, they still had a sort of dormitory, very institutional style. There was a lack of activities, lack of access to fresh air, and interestingly, they estimated that although there were lots of therapeutic rooms and activities available theoretically, actually only roughly 5% of the patients there benefited from those sorts of therapies. They were very critical of the medication-only approach. There was no sense of a multidisciplinary style approach to mental health or recovery. And they observed the papers of one 49-year-old patient who had died and he had a known cardiac issue, and he was subject to polypharmacy, including 5 antipsychotics that included clozapine and olanzapine. And so they were very critical of the sort of lack of human rights infrastructure in the hospital, and talked a lot about this, the pretense of the voluntary nature of the patients. And because everyone was classed as voluntary, of course, there was no court, because you only get the court review if you're classified as being an involuntary patient. And so in this hospital, going back to the previous slide of 3 basics of the rule of law in mental health, of information, the court, and the lawyer, all 3 were absent, the CPT found, from the psychiatric hospital in Daugavpils and Aknista as well. And so that's just an illustration. That's not a unique situation. It's an illustration of what I would say is still the norm across Europe in terms of the compulsion end of mental health services. So Danius Purus, who was the UN Special Rapporteur on the right to health, he has said that the mental health system, his words, dominated by reductionist biomedical model that uses medicalization to justify coercion as a systemic practice and qualifies the diverse human responses to harmful underlying and social determinants such as inequalities, discrimination, and violence as disorders that need treatment. It's powerful stuff. And he has observed that in the mental health arena, actually the CRPD is undermined and neglected. And in my experience, it's almost unknown, unheard of, or deliberately not discussed by mental health professionals. And we see in this country and many other EU countries that although the buildings have been renovated, often with European Commission funding, that's an investment into institutionalization, but the culture has not been modernized. There's limited development of community support systems, and although, especially tomorrow, we'll hear lots of good examples of alternatives to compulsion, those remain pockets, tiny micro projects of good practice or promising practice that have not been scaled up by governments. Within this world of mental health, psychiatrists still dominate. They still have the ear of ministries of health when you're talking about mental health law reform, and users and survivors of psychiatry simply don't. They are politically invisible and ignored. And where you do have judges being involved, many times these are very short hearings, if there is a hearing at all. And in some countries, this is just done on paper, and essentially the judge just gets out the rubber stamp and endorses the psychiatric decision. So it's a foregone conclusion, which completely undermines the whole point of having the court involved. And in many countries, there's no legal representation to speak of, or inadequate. And again, there's no real adversarial advocacy, which is what the European Convention on Human Rights requires. So, final slide, in terms of the future of mental health laws. I mean, this is basically a sort of a stakeholder mapping, and there are actions that lawyers can take, there are actions that mental health professionals can take in order to ensure that mental health service users are front and center and enabled and empowered to co-produce the change. Lawyers, and I've emphasized this because there are so many lawyers in the room, it's essential that the Bar Association gets involved to train lawyers, to hold them to account, to accredit them. It's essential that lawyers actually provide proper representation so that they can go home at the end of the day feeling proud that they've done some proper representation and advocacy on a day-to-day basis, but also that they identify, well, where are the weaknesses in the law? Where does the law in Latvia not align with the European Convention or the CRPD, and just identify where those cases are and take those sort of strategic cases. And of course, there needs to be legal aid. We're here in a university. I'm not sure what the situation is with legal education in this field, but in most European countries, there is nothing about disability law or mental health law at the undergraduate or even postgraduate legal education. And also national human rights institutions, and here you've got an NPM, National Preventive Mechanism, at the Ombudsman's Office, need to be there at the forefront, as they are doing here, monitoring what happens inside closed institutions and monitoring the change process. Hopefully that was useful. Thank you very much.
Thank you. So now we are unfortunately out of time, but I'd still like to open the floor for a few questions, maybe burning ones. So just raise your hand and then wait for the microphone to reach you, and then please state your name and affiliation. It's here in the front.
I'm chair of the European Network of Ex-Users, Users and Survivors of Psychiatry. I have to say that I myself experienced lots of violations, including the fact that I signed informed consent to my treatment 3 times without knowing what I am signing, exactly because nobody was interested in my consent at that point. My colleagues in different European countries are also experiencing similar problems. And we think that the standards that are used by CPT are really outdated at this point. When CPT, I'm myself a monitor of NPM in Georgia, my home country, and I was included in NPM of Georgia exactly because of my lived experience. So I'm not a lawyer, I don't have required qualifications to be an NPM member, only the fact that I have lived experience and practice in NGO sector. And for years, I've been monitoring institutions and services from 2014 at the Ombudsman Office of Georgia. And it can be said that involuntary measures come in package. CPT tries to distinguish between like placement and treatment, but if you are involuntarily placed, then all other measures go in one package. It's possible to just manipulate with the fact of involuntary placement, just to say, I will release you if you consent to treatment. And the person will be just thinking whether he wants some legal proceedings with no result or just practical result right now. And the person usually decides to have some results right now. And that's how, by the way, in my home country, this informed consent is obtained. 90% of patients in our country are there based on the informed consent. Just because the lawyers exist, yeah, we have court hearings, but it doesn't make any difference. Because professionals who obtain informed consent say, either you consent now or you will be submitted to court procedure and the court will leave you here for 6 months. So they provide some information, but the information is not quite full. So it is always possible to manipulate with people, especially in vulnerable situations. And therefore, the attempt at going into details and which form of coercion goes with what and which form should be separate, in our opinion, is a bit of waste of resources, especially because of CRPD and the new paradigm. Daniel Spiras, who was in Georgia not so long ago with training, he was commenting that sometimes it may be the case when a report is published highlighting bad violations of human rights, the photos are visible, and then politicians decide to repair the institutions because of these horrible photos. And then they think that it is okay. So they do not deal with changing the service and the culture. They deal with the walls of the institutions based on reports published. So the point I wanted to make is, apart from the points Mr. Oliver said are necessary, that we agree, of course, it's key to involve representative organizations of persons with psychosocial disabilities in their political decision-making, because when such services and legislation and strategic plans are designed, usually we are not present. And then, of course, it's very easy to override our opinion, and it's not a meaningful consultation later when it is already created and you can change nothing, you know. Then resources must be put in place to empower these organizations, because sometimes, and at the European level we have the situation, we are approached for some feedback, but no significant time is given, neither resources to consider seriously the questionnaire or a reform provided to us, and we cannot simply provide quality feedback in many cases. Because of these resources, constraints in resources, the lack of also human resources available if the organizations are not so well developed. So it should be an obligation, and it is an obligation of the state to empower organizations of persons with disabilities and include them in the political process. And the second very big point is to involve and activate mechanism of monitoring according to CRPD standards, not to the European Convention and the CAT standards, because we need these CRPD standards in place. And we need not only monitor institutions, but we need also to monitor community services. Because in many cases, community services exist, but they do not operate normally. And they also can successfully use coercion, which is the practice. So it is necessary to activate a mechanism of monitoring envisaged by Article 33 of CRPD, and of course to ensure participation in this monitoring process of representative organizations of persons with lived experience, and ideally persons from these institutions and services who are service users and who can provide this very valuable information about how the services function from inside. We hope that changes will be made. Eventually, some progress maybe, can be visible in some countries, but still it is very slow, and we just need something more quick to achieve changes in our lifetime. Thank you very much.
Thank you for sharing your experience. We'll be discussing the monitoring also on tomorrow's conference. There was another question there, and then I think we'll have to finish.
It was actually more a remark. So I don't know, I can make it, I'm actually chairing the next session, so I'll do it for the sake of time. I can do it in this context if that's easier, just for everybody to have the break on their time. I actually had a question for Jorge, but I guess he's actually gone because he said he can stay only a few minutes. That's okay, he'll come back tomorrow, so hopefully I'll have the opportunity to put the question, so don't worry, I'll make my comments at the beginning of the next session.
Okay, thank you. So thank you for your attention. Thanks to all the panelists for interesting and informative presentations. And then let's meet at 4 o'clock for the next session.
Oh, you can? Oh, I can do it. Okay, good. So we are entering into the last phase of this symposium, and it's my pleasure to chair that session. I'm Laurence Lvoff. I'm the head of the Human Rights and Biomedicine Division of the Council of Europe that is organizing tomorrow the conference together with the Office of the Ombudsman from the Republic of Latvia and the University of Latvia. I'm very pleased to be part of this symposium today. And we're going to go into the national legislation matter, but I just wanted to make just a remark in this context, because I think we saw from the presentations earlier today the importance of the concept and clearly use appropriate terminology in the context of a legal analysis. And in particular, to make a distinction between legal personality, that is a requirement from any persons entitled to have rights. The notion of legal capacity, and as actually Jorge Reyes mentioned, the difference between legal capacity and ability to decide. And I also think that there's another important element, which I think I wanted to underline, is when we are discussing this consent issue or decision-making issue, it's also important to contextualize what we're talking about, which type of intervention, which type of treatment we are considering. Because the situation may be completely different if you're looking at a situation where you are considering a treatment for addressing the situations where the life is immediately at risk from an intervention for a treatment of something where it's bad, including the example that was given earlier today by a colleague from UK, even with the beginning of a gangrene, for example. That is different than when the life is at stake immediately. So I think it is important to look at this from a case-by-case basis, and when we talk about treatment, to specify what is the object of the treatment and what are the circumstances we're talking about. And hopefully in the national legislation, that will be the focus of our sessions, we'll have some insight of this for 2 countries. And I'm very pleased to introduce our speakers today. We will benefit from the Irish experience, thanks to Professor Deirdre Madden from the University College Cork and School of Law. And then we have 2 speakers to present the experience in Latvia, our host country today. Professor Dr. Solvita Olsena, well known to the Council of Europe, and also Dr. Laura Cadile. I thank you, the 3 of you, for your contributions, and immediately give the floor to Professor Madden.
Good afternoon. Thank you very much for inviting me to this wonderful conference this week. It's a pleasure to be here. This is my university in Cork, where I specialize in medical law and ethics, and I'm delighted to have the opportunity to talk to you a little bit today about the Irish approach to assisted decision-making. I'm going to speak at a very broad level about our new legislation, which has now been in effect for about 6 months. So we don't have it all figured out yet, but we have made a good start, I think. So the process for the introduction of our legislation really began quite a while ago, maybe around the early 2000s. There was a lot of campaigning for reform of the law through disability rights activists and advocacy groups, in particular human rights organizations, followed by consultation papers published by our Law Reform Commission, which is an organization that was set up to propose recommendations on law reform to our government, some of which they act on and some of which they don't act on. So there were papers published in 2003 and 2005 on protection of and respect for human rights of persons with disabilities and vulnerable people. So following those proposals, the Irish government in 2007 put forward proposals for legislation which aimed to facilitate the ratification of the CRPD. And this meant that there were a number of law reform projects that Ireland had to put in place in order to provide appropriate and effective safeguards to be compliant with the CRPD. There were lots of public consultations and parliamentary hearings on the draft legislation. There was a lot of concern expressed about the legislation that was drafted because of the focus on substitute decision-making, minimal safeguards about informal decision-making, and also, and in particular, the use of the term best interests that continued in that draft legislation. So following all of that public consultation, the government then revised the proposed legislation and finally published the Assisted Decision-Making Capacity Bill in 2013. And the bill, as you'll see from the slide here, was one of the most debated pieces of legislation in Ireland. There was 14 parliamentary debates and multiple revised schemes of the bill. It was finally passed into law in December 2015, but it was not commenced, it didn't take effect until April of this year. So a very long lead-in time, a very long preparation time from 2015 to 2023 to enable codes of practice to be drawn up, you know, a lot of bureaucracy, a lot of preparations and guidelines had to be put in place before the Act was commenced. So we're 6 months post-commencement now, and we're still figuring it all out. So just to mention the compliance aspect with the CRPD, so the central tenet, as you all in this audience know, of Article 12 is to ensure that all adults are provided with the opportunity and support to participate as equal citizens. So the new law in Ireland has been described as this seismic or huge cultural shift away from a paternalistic and best interests approach to a rights-based approach of choice, control and consent. And that description is from one of our patient advocacy organisations. So they see it very positively so far and hopefully are very supportive of it and the change that it will make. So obviously this is going to require a very significant change in terms of culture, and it will require a lot of education and training, time, resources, skills and competencies, leadership and collaboration, public information campaigns, which we already have in the media. We have big public billboards posted around our cities and countryside, telling people what their rights are and how to access their rights and how to engage with this new legislation. So there were a couple of declarations and reservations that Ireland made in ratifying the CRPD, and very shamefully, I think Ireland was one of the last, if not the last, European country to ratify the CRPD, which was a huge embarrassment to us who work in this area. So Ireland declared its understanding that the Convention permits supported and substitute decision-making arrangements which provide for decisions to be made on behalf of a person where necessary and in accordance with law and subject to appropriate safeguards. So to the extent that Article 12 may be interpreted as requiring the elimination of all such decision-making arrangements, Ireland reserved the right to continue to permit such arrangements in appropriate circumstances, and I'll explain those a little bit later on. So the rationale was to make sure that there were no difficulties encountered in the operation of our new legislation, which I've synopsized as ADMCA, the Assisted Decision-Making Capacity Act. So that act does allow for the appointment of a decision-making representative to take decisions, specific decisions on behalf of a person. And then the second point is Ireland also declared its understanding that the Convention allows for compulsory care or treatment of persons, including measures to treat mental disorders as a last resort, and again, subject to strict legal safeguards. And I'll mention those a little bit later on. So just to mention, I suppose, the Act in Ireland is very clear that it does not distinguish between people based on age, disability, health condition, mental disorder, behaviour. Everybody is entitled to the same presumption of capacity and the same protections of the legislation. So we estimate that there are approximately 200,000 adults living in Ireland that could have decision-making capacity difficulties, but of course each of those people may or may not come within the ambit of the Act, depending on an assessment of their own individual circumstances. Any of us, indeed, could find ourselves incapable of making decisions either temporarily or permanently, so the Act is truly an act for everybody. So what's changed since April 2023? I suppose the main principles that have changed is that we no longer use the term best interests in making decisions for people without capacity or with capacity difficulties. That's probably the biggest change, and that will take a long time to embed and be integrated right across our system, not only in healthcare, but right across all sorts of, all aspects of society. So it's going to be a huge cultural shift. And when we say the will and preferences of people are at the heart of decision-making, our legislation is very specific that we must give effect to the person's will and preferences, not consider, not think about, not take into account. We must give effect to the person's will and preferences. So that's very strong, respectful language, I think. And then the other point, I think, and this is perhaps more in the healthcare sphere than others, is that there is a role reversal from for healthcare professionals from being a judge of somebody's assessment, or somebody's capacity, to an enhancer of somebody's capacity. So it's not just your role to assess whether somebody has capacity to make a decision and to be a judge of that. Now you have to engage with the person to promote, to support, to help, to enhance and facilitate them making their own decisions. So this is going to require a lot of change in practice, I think. The guiding principles that are set out in our legislation, and some of these have already been mentioned, and I won't dwell too long on them, but obviously the presumption of capacity is very important. It's key to the whole Act, and that's something that we keep having to, I suppose, remind people about when we're doing training on the Act, is you always start with the presumption of capacity, irrespective of somebody's perceived disability or disorder. So presumption of capacity applies to everybody. We also apply the functional test of capacity, which is, does the person understand the information when the information is given to them in a way that's individualized to their needs? Do they retain the information long enough to make a decision? Can they weigh up the information to look at the risks and benefits of the decision? And can they come to and communicate a decision? It has to be time and issue specific, so it has to be specific to the question you're asking them to make the decision about, and it has to be specific to the time at which the decision is required to be made. There is also a legal duty in the legislation, which I think is really important also, a legal duty on all of us to maximise somebody's capacity and to support them in decision making, to respect people's choices, even if others consider them to be unwise. I've already mentioned that we must give effect to their will and preferences and then consider their beliefs and values, even if the person lacks capacity. And that might include checking whether the person has an advanced healthcare directive, for example, and giving effect to that. The Act also requires the intervener, the person who's providing the intervention, to consult with legally recognized persons that have been nominated by the person who's now being asked to make the decision, or by the court if the person lacks capacity, and I'll explain that in a moment. Apply the least restrictive interventions, so it must be as limited in duration as possible, it must be necessary and proportionate, must have due regard to dignity, privacy, autonomy. You must consider the likelihood of the person recovering their capacity, the urgency of the intervention, and consider the views of any named persons, any carers, anybody with a bona fide interest in the welfare of the individual, and also healthcare professionals. And then having done all of these things, the person who's providing the intervention, for example, a doctor, must act in good faith and for the person's benefit. So supporting decision-making is crucial. A person will not be regarded as unable to make a decision unless all practicable steps have been taken to help him or her to do so. Of course, there's no one-size-fits-all way to support everybody. Everybody has their own needs, their own way of understanding information, their own way of coming to a decision and communicating. So what supporting someone looks like will depend on the decision to be made, their ability to understand, their ability to communicate, whether the person's used to making their own decisions, because if they've been living in a residential institution, perhaps they're not used to making their own decisions, so they need to be supported and helped to learn how to make their own decisions. And also, of course, the time available. Other key aspects of the new Act, I've already mentioned refusals of care. An important aspect for us is that the wardship system is abolished. So this was a system that we had in existence since 1871. 1871 until 2023 is a long time to have the same system in place. And it was under regulations very unfortunately called the Lunacy Regulations Ireland Act from 1871. So this was a very offensive type of system, by which somebody would be taken into the protection of the state, the protection of the court, made a ward of court, if they were described by the court as a lunatic, an idiot, or a person of unsound mind. So we had this in our law until 2023, when this act was commenced. So completely inappropriate and offensive and not in compliance with any form of interpretation of human rights. So this has now been abolished. We have about 2,000 people in Ireland who are currently wards of the court, and all of those people will have their wardship reviewed within the next 3 years and appropriate support mechanisms put in place for them to support their needs. We have also extended our powers of attorney legislation to healthcare. We've recognised advanced healthcare directives, and we've put in place, and I think this is probably the biggest difference maybe that Ireland has in its legislation from others, is a continuum of decision-making support options to respond to a diversity of support needs, recognising that people's capacity, generally speaking, unless they're in a catastrophic accident, doesn't go from 100% to zero overnight. It may decline over time, it may fluctuate. So our legislation is trying to put in place different support systems to meet the person where they're at that moment in time in their life. So the different options that we have, these are new, 5 new roles, I suppose, people with legal authority to support decision-making, ranging from assisted decision-maker to designated healthcare representative. So all of these 5, except for the one in yellow, which is a decision-making representative, all of these others are people appointed by the individual whose capacity is in question. So if it's me, if I perceive that I'm experiencing challenges with making decisions, I will appoint either an assisted decision maker or a co-decision maker to help me. So an assisted decision maker is somebody, usually a member of my family, who I will ask to help me and support me to gather information, to explain things to me, to access my healthcare records, to help me weigh up my options. So I will decide who it is, and I will decide the range of the supports that I need. So the person that I appoint has no decision-making role. Their job is to help me. The next one then is a co-decision maker. This is again somebody appointed by me. In this case, it is to make decisions jointly with me. So if a contract is required to be signed, they will also have to sign with me. So this is obviously where I feel perhaps that I need a little bit more help and a little bit more protection. But again, it's entirely up to me to decide the range of those decisions that I want support with. And who I want to be that co-decision maker. Then when it comes, perhaps the person is perceived to lack capacity to make certain decisions, an application then can be made to the court to appoint a decision-making representative, which is the one in yellow here in the middle. This is the only one of this range that is appointed by a court. Everybody else in this range of options is appointed by me as the person who has challenges with capacity. So the decision-making representative will be appointed by the court. The court will decide what decision-making role or the limits of the role that that person will have, whether it's about personal welfare, financial matters, healthcare decisions, and so on. They will try to appoint a member of the person's family where this is appropriate. It may not always be appropriate, or there may not be a family member available, in which case they will choose somebody from a panel that is going to be appointed of people who will be appropriate to act in this role. So then the last two, the enduring power of attorney and designated healthcare representatives, are where you anticipate that at some point in the future you might lose capacity and you want to have a support option in place or a substitute decision maker in place if and when that ever happens. So these are anticipatory decisions. So an enduring power of attorney would be somebody, again, that I choose, that if I ever lose capacity, I want them to, in a sense, stand in my shoes and have the same legal authority that I do to make decisions on my behalf. And then the designated healthcare representative is specific to advanced healthcare directives. So it's somebody that I would appoint to make sure that my wishes in relation to my healthcare in the future are interpreted in accordance with my will and preference. That person may also give consent to or refuse medical treatment on my behalf. So that's the range of new roles that the Act has devised. The government also established a new service called the Decision Support Service. So this is part of the Mental Health Commission, which regulates mental health inpatient facilities and sets quality and safety standards for persons with mental health difficulties. So it sits under the Mental Health Commission, but it has a separate role. Its job is to protect and uphold people's rights to make their own decisions. It will regulate and register decision support arrangements. It acts as a supervisor for people who are appointed into these decision support roles to make sure that they are complying with the law and make sure that they're not in any way abusing their role or abusing their function in relation to the person that they've been asked to support. They will maintain panels of people, they will investigate complaints, and they have a very strong public-facing role to make sure to promote awareness and provide information about the Act. So then just finally to finish with, I suppose, the application of the Act to mental health. So as I said at the start, our legislation applies equally to everybody. People with mental disorders being treated in the community or in approved mental health centres are, of course, have the benefit of the Act in the same way as everybody else. If a person who is an outpatient or a voluntary inpatient has a decision-making supporter from the list that I had on the previous slide, that person must make decisions in accordance with their will and preference. So the decision is the same as if the patient had made the decision themselves. None of these support options that I had on the previous slide enable a person to be compelled to accept treatment unless they meet the criteria for involuntary admission and are deemed to lack capacity. So the Act, of course, does not authorise coercion. Now, we do have separate legislation called the Mental Health Act of 2001. This is currently undergoing reform. Under that Act, there are two grounds for people to be involuntarily admitted. One is the risk ground, if they're perceived to pose a serious immediate risk to themselves or others, or secondly, where their judgment is perceived to be so impaired that failure to admit them for treatment would be likely to lead to a serious deterioration in their condition. So if a person is involuntarily admitted, then consent is ordinarily required, of course, except if the person lacks capacity and the psychiatrist feels treatment is necessary to safeguard their life and health. So There are questions about inconsistencies between our mental health legislation and the Assisted Decision Making Act, and we are expecting further legislative alignment of those two pieces of legislation shortly. There was an amendment to our Mental Health Act in 2018, which specifically said that the guiding principles of the Assisted Decision Making Act also apply to mental health. So that was enacted in 2018, but it has not yet been brought into effect or commenced. So we're still awaiting that. And just to conclude, of course, the Act will be a challenge. As I said, we're only 6 months in. It is a fundamental change to existing practice, and this change, culture doesn't change overnight. It takes a long time. The aim is to make sure that everybody, at least in the health service, and that's, I suppose, where my background is, that everybody receives a person-centred service, that they're truly listened to, they're given information in a way that they can understand, and the information is tailor-made to them, and that everybody is supported to make their own decision in a way that's right for them. It's supported by all professional organisations and regulatory bodies in Ireland, and the hope is that it, like all culture, I suppose, it just becomes the way we do things, and it's just normalised and accepted into normal practice. So I'm happy to answer any questions, and I'll leave you with some beautiful photographs from Ireland. Thank you.
Thank you very much, Professor Madden. I think it calls upon many questions. It was really interesting. But we'll keep that for the end of the session, and I'll immediately give the floor to Solvita. I think you have 20 minutes altogether with
Jā, labdien visiem, man tiešām.
Hello, hello. It is my real pleasure to welcome all our guests here in the University of Latvia, all my colleagues, all presenters. I'm really happy to share results of our study, and we performed our research within the framework of our study, and this is already the third year, and together with Laura, who is also a researcher, we will provide to you initial conclusions regarding case law in Latvian courts when treating people with mental disabilities. I just want to tell you that we are just summarizing what the court has said here in Latvia. We do not have time to provide reflections on what we could do tomorrow or after tomorrow, but our study will provide us with ability here in Latvia to choose steps which we can make tomorrow or in future, where Ireland already is today or our neighboring countries are heading to. Before I start my presentation and results, and I would like to thank all our cooperation partners or regional courts and all courts in Riga city, which really help us, who really are warm and welcoming, and it's very nice and interesting to perform study in courts. I also would like to thank court administration and also Ministry of Justice. We cooperate with them. Also, they support us with information, and they are really interested in the results of this study. So thank you very much. Only together with you we can make these researchers and also provide results. So we have very wide goals, but this is a goal to investigate or examine the practice of Latvian courts when decision is made on human rights protection and restriction of people with mental disorders. And why we would like to do that? Because we would like to draft proposals for protection of these rights. Methodology we are using what similar studies are taking and using qualitative content analysis. We have not made so many use so many these pieces of information, but we see that here court decisions for providing psychiatric assistance without patient's consent, and here we see the numbers of people who have been treated without consent. And here courts have been deciding on treating people without their consent. Here you see statistics. We have taken each 10th case, so we think that we will get quite well and quite good representative sample. And besides that, we also have looked through the related court judgments which are related to the Article 68 of treatment law, where a court has been deciding on restriction of capacity and so on. And what we as researchers see, and the results, so Laura Kadile will tell about this because we are doing this together. So we also have clinical psychiatrists, not only lawyers, and we have quite broad view on this. Good day. So this section was already mentioned today several times, but for not you to read, so this terminology which we are using here in Latvia, I have outlined two models, and that is easier to see. So our national legislation stipulates when psychiatric services are provided to a patient without consent. So the first model is when he or she had threatened or tries to make bodily harm or is violent to himself or herself or others, and also there are been the disturbances of psychiatric health and which could lead to different violences or consequences or bodily harm. And another model when a person is unable to take care for him or herself and themselves, which we also saw in court decisions and statements, then when a person shows inability to care for himself and others, and plus the same what was mentioned in the first model, when there are health disturbances of mental order, or it could be also health deterioration, and then it is also a court decision on forced treatment. To tell what methodology we are using and also looking at the example of other countries, so how we do this, so we were concentrating on all previously mentioned terms which I mentioned. And additionally, we also tried to find how court are evaluating patients' ability to take decisions and whether we can make conclusions that autonomy is taken into account, or also ability to take a decision. Are they included in those judgments? And also today I will tell what we see in these cases. So the idea or the term of the ability to decide or decision making, so we do not have such a problem in Latvia, but anyway we see whether we have any relationship, what the court is evaluating, what the court is really doing court admits that patient is not in the status that she can decide on her own health situation and necessity to treat the treatment. Additionally, cannot understand and cannot take care of herself, also this ability. In another case, court says that for 2 months, having been treated in an institution, patient understands situation, or a patient is able to form logical and efficient sentences. And in some judgments, we see that the court has seen adequate communication if the patient is present. Then the court sees that the explanation is logical, and also mentions behaviors, that it is adequate, that explanations are logical, understandable, answers provided to the questions. And some cases when the patient is not cooperating, when do not understand what is asked, do not sign documents on consent on treatment, and also is deprived of realities. This is what we heard today. And also we see that the patient is non-critical towards own health status. And so the question is, what is non-critical attitude? In most of cases, we saw mentioning critical or non-critical attitude towards health situation and other aspects. And then, of course, the question, what do we understand with non-critical attitude? And when evaluating those elements in more detail, we saw that threatening themselves or others, this is explained as detriment to their health, for instance, overdosing medication, or psychological disturbances, aggressive towards themselves or others. And also one example which shows opposite. In one thing it says, in one case it says that a person, that in the onset of the sickness, a person has been acting strangely, screaming at the passers-by and threatening people, children, and this is dangerous for the society. Also, it is in one case, it says that without treatment, patient can physically not only threaten himself, but also relatives and other persons. The question is, what is probability? And here also we also conclusion that the judge, when seeing patient, is not sure that he could be able to harm anybody else, or could be aggressive, or and vice versa, says that the person is cultural, patriotically, and stately loyal towards person, and due to the age cannot make harm to other people. So here we see discriminating aspect as age, and how she evaluated the person, the patient, and this is really a problem in Latvia. And then regarding the bodily harm, so it seems more simpler. So there are ideas expressed about suicide. There are also some attacks on relatives or medical staff, physically aggressive and impulsiveness, not to be admitted as adequate, and is not understandable for a grown-up. It is not a normal reaction of an adult person. That is not adequate. And this is not a normal reaction towards restriction of freedom by institution, and there also a judgment when the aggressive activities, when the emergency has been called and police was to be explained with unwillingness to go to the hospital. There are also other elements, but we see that the fact that I am moving my hands or legs doesn't mean that actually this element is understanding within this law. And then also we have enlisted those who understand Latvian. You see that we all normally see these 5 or 6 types of mental health disturbances. So most often this is schizophrenia and also the schizoaffective disturbances, the demence. It's also alcoholic dizziness, also acute polymorph psychotic disturbances with schizophrenia symptoms, and then we also try to find what does it mean inability to take care of themselves. And then it is mostly explained by not being aware of health condition and also necessity to treat this status. And also a quote says that the patient observes hygiene and accepts food only if it is offered, and this means that the patient cannot take care of himself or herself. Also, the ability to take decisions on the health and eliminate the detriment, and so when decision is made whether the person can take or not take care of himself, also cannot objectively understand the health status and behavior, and also and the mere saying that a person doesn't want to take food, it means that the person doesn't want to take care of him or herself. And also there are different problems and challenges which are widespread and also expressed more widely in the project. So there are problems which we really see when we read these state judgments, and so we know it by heart already almost. That there are some of them. First of all, these evidences are not taken as one set. The most popular is said that the court stipulates that the court agrees and they do not have any reason to doubt opinion of doctors regarding the condition of the patient, and this makes impossible for a patient to have outpatient treatment. Also, second one, it is inpatient and curing in the institution. So this we think that this is discriminating conditions that court is taking into account previously made the diagnosis. And of course, this can be true, but and also. Court is not taking into account the possibility of the person to be treated outpatiently. To be an outpatient, and the things that the person agrees to treat outpatiently, that doesn't mean that he's not taken to the hospital anyway. So, and also the fourth one is the decision of Consilium of Doctors. So it is being said that the factor of the illness and also influence on the health status of the patient. So special knowledge is needed in psychiatry, and there is no reason to doubt the psychiatrist's decisions. Of course, there's a decision, but the courts, if we say it like that, then we could close all courts at all, because then we take an expert and that's it. And then we have conclusions. And within the last 4 minutes, I'm going to tell you our conclusions.
So, yeah, few minutes still left.
Sticking to my language alma mater, tātad secinājumi būtības.
So conclusions. So I have already outlined the most important aspects. We haven't the statistical data compiled and summed up yet because the research is ongoing. We have only several court judgments when the deprivation of rights and incapacity of a person was supported by the court. Sometimes it is not mentioned specifically what has been the argument for holding a person in an institution, or what happened if a person refused to sign one or other document, and that court did not evaluate all a set of evidence being provided and status of a disability, which I haven't mentioned before. For instance, if a person has a disability and it is indicated, it is not assessed as a legally significant circumstance. At the same time, we have seen that, for instance, if a person has long-standing mental disorders, and there is no doubt that the matter on protecting the rights of a person with disability should be considered. Ability of a person to decision-making and acting systematically was not assessed. Sometimes doctors felt quite free to determine that treatment would be needed for several months or for 2 months, and no justification was provided, and court didn't assess the lack of such argumentation and justification. And to sum up the topic of the symposium today, if condition of a patient improves, the court doesn't consider it to be a circumstance to revoke or cancel that restriction of autonomy and rights of a person based on the application of UNCRPD. There have been only few cases among court judgments and court decisions that our courts in Latvia would apply sections or articles of that mentioned convention. Thank you for your attention.
Adele, I'm sorry to rush you. I was just hoping to be able to take a few questions before the end of these sessions. Yes, please.
Thank you. Thank you very much for all three of those presentations. This is a question for Deirdre. Does the 2015 Act comply with the Convention on the Rights of Persons with Disabilities?
That's a very difficult question for me to answer. I suppose it complies with our understanding in Ireland, given the reservations and declarations that we've made. There's some criticism, obviously, in relation to the forms of substituted decision-making that we have enacted in our legislation, and we'll wait and see what the reaction, I suppose, of the committee is to the reservations and declarations and to the framework that we have introduced. But it was deemed necessary in order to still be able to protect the people as a last resort who require protection, and that's how our government has interpreted it. So I can't answer for the government. That's the declaration and understanding that they made and the framework that they introduced in order to have that protection still in place. But I guess I have my doubts.
Another question? Yes.
Paldies.
Thank you very much. I would like to ask a question to both researchers from Latvia. Thank you for the research ongoing. What would be? So we have heard that in the not doubting of the decision or a judgment made by psychiatrists have not been voiced. We are not catching patients on the street. We have quite a lot of patients, and we of course could miss so we wouldn't have so much work to do. But what is the credibility to decision and treatment provided by psychiatrists to patients for conclusion not be made that court should revise or reconsider some decision or argumentation provided by a doctor, by psychiatrist in treatment of a patient? I would provide a short answer. We must understand that court has another role. Court doesn't have the role to believe in doctors, but to check evidence, to verify evidence, and decide on a restriction of a person's rights. Prosecutor must protect the rights of such person on behalf of the state and to follow and to observe so that patient or a person would not be harmed. So court proceedings is not about belief or disbelief. Everyone must take and do one's job. So courts must rule, and psychiatrists and doctors should treat, and people should be informed. Everyone is welcome to the conference, which will be held in May next year, but a psychiatrist has his or her role, a medical team has its role, court has its role, and human rights is a topic for us as providing service to people, to person. So, court must verify whether the psychiatrist has done his or her job or role full-fledged. How that could be done is the next question. How judge can do and how he could do if psychiatrist studies for many years. So I'm a sworn advocate as well, and judges in administrative courts who are specializing in the cases of such type have accumulated quite an experience already. If we are speaking again and again on the same things and what we plan and what we offer, how good and well that would be to one individual, to another individual, etc. I'm specializing in medical law for many years, and communication among different and various specialties would lead to a common conclusion. We can agree and we must agree. We must come together more often and develop the capability and ability and skill to do so. We must come together interdisciplinary and to find a solution. And that would be my inspiration to that as well. I would like to supplement my colleague. I have a thesis developed on decision-making and capacity. It is not a reprimand to medical professionals, but court as an constitutional body may not. So every court judgment and decision and case should be considered very thoroughly, and we may not omit something. And when legal consequences are provision of medical treatment without consent, additional mechanisms should be ensured for us to observe a patient at courtroom by asking additional questions. I hope that we will reach a system when four-step decision-making or capacity or capability would be introduced in Latvia. So, for instance, for a legal transaction to be admitted or recognized as cancelled, when a person is or is not capable of concluding such transaction. And we also see those trends in court judgment as well. It is a task of court, of lawyer, of advocate, of every stakeholder to really implement and make the convention and respect of convention in practice. So I didn't get your answer very clearly. But but I can read and understand that psychiatrists are not the ones to blame, the only ones to blame, and lawyers have some part and share in that as well. I'm a judge from Zemgal region. I would like to thank the researchers for their presentation. I have the first question. How you study and research, how that proceeding or process is made? Do you read and study only these written court judgments, or you have also participated in some court proceedings at court sitting? How it actually takes place in practice in life? It was a long way. Where should I start? When we received an opportunity to access those cases which are decided in closed, which are actually made anonymous and are not available. And in our gratitude to all of those mentioned on the screen, the courts from particular regions, we really got access to all the court judgments in respective court houses. And as financing of our research is provided for certain years of our research, we considered that it was a good idea to study every 10th court judgment, which complied with also international methodology. We isolated and identified those elements which resulted from section number 68 of treatment law of Latvia. We received all the case files of those court judgments. That our team included also doctors and psychiatrists, and if any matter was not perceived by us as lawyers clearly, we advised our team members, psychiatrists and doctors. But of course, we focused on court decision itself. And the second question, how do you conclude that court or a judge has not evaluated all the evidence base? How did you come to such a conclusion? So, studying a court judgment or decision, we have also mentioned that a judge indicated that patient was not critical towards one or other matter or issue. Those assessments in court judgments repeated very often, and we had a question what was assessed so that a judge would reach such an conclusion or statement. Many court judgments, although in Latvia and other countries, dogma and phenomena that courts state that they cannot check and verify medical statements and medical conclusions, and courts state that there is no grounds to dispute decisions made by and facts mentioned by Consilium, or College of Psychiatrists, when the elements from the law were included, and that phenomena repeated again and again in court judgments. And our conclusion is, and our recommendation will be, which is assessment of evidence, whether evidence is really credible at the disposal of court, with which particular actions a person concerned or person disputed has threatened others or would have threatened. If not medicated, then will threaten or jeopardize others. And what would those actions would be? Courts hadn't asked another statement. what person will reach and achieve if a specific medication recommended or advised by a college of doctors would use. How court can decide that medication should be used to be achieved by a person, and what of the assistance and help would be. I really respect your opinion, but I would receive an answer to my question. What is evidence which is not evaluated? You study some case file, you see one and other evidence, and you conclude that court has not assessed all the evidence in the case. My question is direct. What is that evidence which was not assessed? So first of all, court doesn't ask for evidence very often. Court really relies on opinion of one party to the dispute. And Laura, please pay attention. So court doesn't ask evidence. Court considers and perceives that what college of doctors has written, that is credible. So a person has attacked somebody. We know from the case file, from the facts, from the clinical expertise, that video record from the episode could be asked whether a patient was not provoked. Did anyone calm him or her down? Court didn't ask anything, any evidence to justify the facts. Secondly, in those cases, when it was shown and written that a person in question, confirmed that he or she had done one action, second action, third action. This is our researchers' opinion, that to our opinion, court does not evaluate that as a significant fact. For instance, if a patient has stated at the courtroom that he or she would like to have outpatient treatment, and that is not considered as a fact, as a justified fact. And our question is why? I have more specific question. What would be evidence to your opinion which should be included, from whom they should be asked for, or who should provide that evidence? And what is the role of a judge to really have that complete picture? Who would collect that evidence, and what evidence should look like, and what would be the role of judge to obtain that evidence? So we have to finish quickly. So we will work on that issue, and in total description of our research, we will prepare, to our opinion and to our mind, what evidence court could request on the following facts. We know that, for instance, about a threat and so we have CCTV in many clinics, and court could take a look what situation it was, whether a episode of aggression described in a statement by College of Doctors actually took place. And unfortunately, at this moment, we cannot discuss more deeply, but thank you very much, especially to judges, and we would be happy if we had an opportunity to exchange our opinions, and we will continue our discussion, our conversation, because we have a lot to say about persons who should be listened to. And I understand that, of course, there is a very great concern that we do not have capability and skill to evaluate that in 72 hours, so significant issue of person's life and capability has been considered at courtroom. and there are some references to international documents begin to appear in court judgments and ability opinion of sworn advocates presented, which is already justified and relying on international legal acts. But let us continue our discussion. If you need, I can also serve and provide my knowledge and my experience.
I'm just afraid that we are getting short of time. We have the pleasure to have the ambassador of Latvia in the Council of Europe present here. I suggest that you keep your questions so that you could put them maybe bilaterally. And I think the only thing that shows this session is that it was a very relevant topic. And there's lots of things to discuss, but that's also the whole purpose of this symposium, is to raise awareness and initiate a dialogue. And I think we're successful in that sense. Thank you very much for all the speakers. So, Mr. Ambassador, you have the floor to conclude this symposium. Thank you very much.
Mūsu simpozija noslēgumā mums ir liels.
At the end of our symposium, we are really honored and really pleasure to give floor to the Ambassador Extraordinary and Plenipotentiary of the Republic of Latvia to the Council of Europe. We would like to thank you for the long-standing cooperation. We are working for more than 2 years just to organize this event, and our ambassador has been the person who has been supporting us, who has been supporting this idea to organize this symposium and conference. Thank you very much for that, and the floor is yours. So, don't I have wings already? No, not really, like an angel.
Good afternoon. I should start by saying that I have one bad news to say and one good news to say. The bad news is that I'm standing between you and your good pleasant evening. The good news is that outside is still raining, it's dark, and then inside here is very cozy. So, I will not take too much of your time, but so let me start by thanking the university for inviting me to say a few remarks during this symposium that is taking place in the new science house of the Latvian University, and which is co-organized by Latvian University, the Secretariat of the Council of Europe, the Ombuds Office of Latvia, and I understand also Ministries of Health and Ministry of Justice, or with support of Ministry of Health and Ministry of Justice. There is another link between this building and the Council of Europe. Actually, this building has been co-financed by the Bank of Social Development of the Council of Europe. So, and the project is ongoing, and I think that the next building, which is under construction, also is co-funded by the same bank. So, Latvian presidency is touching its end in 2 days. The Latvian presidency will pass on the torch of the presidency to Liechtenstein, and it is, of course, time to draw some conclusions and look back. And probably the first conclusion that I could make is that this was really a fabulous opportunity to state the Latvian priorities in the Council of Europe, and to showcase expertise in different areas, including those which maybe are not on every day's agenda. So we chose 3 topics for our priorities, and the first and most important one was promotion of rule of law in Europe in different its aspects, starting with the implementation of rulings of the European Court of Human Rights, specifically looking into the role of national courts in dealing with those judgments. It was accountability of the Russian government for the war of aggression against Ukraine. Also, the issue of return of Ukrainian children to their families, those children who have been illegally deported either to Russian Federation or Belarus. But also we had slightly more unusual topics like the results of implementation of the recommendation of the Committee of Ministers of Council of Europe on the fair trial in anti-doping issues, like a niche thing. But when you look to today's sports world, which is dealing with huge amounts of money, but also is the sort of playground of national prestige, I think that these issues are getting a lot of prominence. And of course, this one, human rights for people with disabilities. Another priority of Latvian presidency was freedom of expression in digital era and safety of journalists, and the promotion of digital agenda of the Council of Europe. And there, of course, we had the privilege to launch the campaign on safety of journalists of Council of Europe and be the first funder of that campaign. And we supported the negotiations of the first legally binding instrument on artificial intelligence and human rights. And the third priority, which was kind of obvious, we took over our presidency on 17th of May from Iceland at the end of the fourth summit of the heads of state and government of the member states of Council of Europe. And this was the fourth summit in 75 years of existence of the organization. And of course, on our shoulders was also implementation of, or launch of implementation of decisions that have been adopted in the summit. So today's symposium and tomorrow's conference is the 17th and the last one event of a substantive event organized in the framework of Latvian presidency. It is good to attend the last event, not because it is last, but because it addresses the topics that is not on on our everyday's agenda. Not to say that in some countries or certain times here in Latvia, this was a rather taboo issue, the same as LGBTI issues. It is considered sensitive, or so sensitive that borders in some people's minds with a sense of inappropriateness to talk about it. I remember myself growing up when it touches mental health. Basically, no one wanted to talk about it, though it was 40 years ago. No, 50 years ago, sorry. That tells me how old I am. And ultimately, it is about our society, our fellows, individuals who happen to have some level and kind of disability. In the rule of law society, an individual should enjoy the same rights as anyone else. I already mentioned that in some societies there is a prejudice about the topic, and prejudice is in some societies bigger than in others. An event like today's allows to exchange national practices from one side and to learn from experience of others. So, and as it was underlined by our ombudsperson this morning, we do not want to leave any member of Latvian society behind. People with social mental disabilities are equally important for Latvian society like anyone else. And the aim our aim is to transform the system of care of people with disabilities based on highest values of human rights and human dignity. As also we heard today, there are international standards. The UN Convention on Rights of People with Disabilities. There is also Oviedo Convention in the framework of the Council of Europe on Human Rights and Biomedicine. And as I understand, they are not really fully aligned, or at least there is a very difference in opinion of governments and human rights defenders. And today's discussion also actually, in certain extent, indicated the tension between different approaches. And again, an event like today provide a platform to discuss these differences. And as stated by Stephanie Woolley earlier today, that we must work together through reforms of legislation, practices, and mentalities to reach the shift in paradigm in the interest of our common humanity. So, and I was very pleased because this was actually the beginning of the project that Professor Olsson presented the first findings of the study in Latvia. So I thought, you know, it's presidency, it's a good way to showcase our expertise and our experience. And even that triggered exchange between psychologists and then judges. I think that is also the reason for studies, to make people think and to think how to improve the system for the benefit of all of us. So thank you very much, Professor, for your initiative. And actually, this is the last that I wanted to say. It was an easy journey because you did all the job, and I was just told you have my blessing. So I wish you a very productive conference tomorrow, and most importantly, successful follow-up in advancing change in societal attitude towards the rights of people with disabilities. And now I wish you a very pleasant swim back to your hotels, because it's still raining as far as I know. And good evening to all. Thank you very much.